Megan Fox has the story.
Megan Fox.
Megan Fox.
Megan Fox.
Megan Fox.
Megan Fox, a national journalist.
Mastodon Drive. I will never be able to say that out loud.
It feels like the Flintstones live there.
It does.
Well, don't trust women. I think you just touched on that with your last. That's what they brought. We're going to have to bring back chaperones.
Oh, Lord Jesus.
And
no.
just careful, Carol. Stop! Break! Ooh. Hard right.
How did you screw up a stove, Megan? You're a woman. I thought that was baked into you, like at the genetic level, how to operate kitchen equipment.
And honestly, Megan, if you don't like it, I'm sorry. I've been very nice to you.
You get Dino hanging out outside chewing on a large bun. I highly recommend being targeted by the New York Times and Rolling Stone for weight loss. And I'd say, keep it coming. I need to lose 20 more. Please keep it coming.
Explain to me, Megan, why did this country not have a holiday once a year? That's the time you vote. If you don't show up and vote, up your ass. You don't get another chance. You don't get, I don't care if you're in the hospital. Crawl to the state, crawl there. But that's it, one day, 12 hours, and then you're done. And you count them that day, and that night you know who the hell won.
I will eat you alive. You want to tangle? You want to go?
The only thing going through my head is, what you gonna do when Megan Fox runs wild on you, brother?
He made a deal with the devil. She's the devil.
He wants that.
Oh, God.
Gross! Oh! All right, penalty box for Slug. Yep.
Of a mile.
Are you ready to behave yourself now, Slug?
This frustrating rep.
Are you ready to behave yourself? Repossessed puppies? I'm hiding Pork Chop! ASAP! Have you seen his little Pork Chop? Oh my God, Pork Chop is the cutest.
That sounds bad phrase.
Have you seen it?
Pork. It's pork.
Welcome back to the show, everyone. It's me, Megan Fox, medium smart journalist, and the show is back. We're back, and we have Laura Owens versus Clayton Echard. An appeal was filed by Gregg Woodnick's office. We do have to read it. It is 63 pages. I know it sounds like pie in the sky to say I'm going to get through it today, but I'm sure going to try. And here to totally not derail me at all and help me do this is that umbrella guy. You're not going to
derail. Never, not me. I would never derail you. I would always keep you right on track.
Oh, well, you know, even if you don't, I still love you. I love having you here. And if you are not subscribed to that umbrella guy, make sure you get over there and do that. Now, just before we went live here, Tug and I were both watching Shara Wolf's latest video on What the Hales. She has dropped a new video. I did put the link in the chat, and also we are going to be hitting that tonight on Tug's channel. So if you are around, you got to be there. Tell your friends. It is something. It's wild. 8 p.m. Eastern Standard Time, 7 Central on that Umbrella Guy's channel. What did you think about that video? Just briefly?
Well, there's one thing in there for sure. I'm just going to flat out say this. So the ecosystem itself has managed to tell us that the messages they keep saying are fake. You know, the ones that Shara put out. Oh, they're confirmed. BBB confirmed them himself. So.
Yeah. So no more. It's fake and they're photoshopped and blah blah blah. He has confirmed it in that. And if you missed it, it was in the portion where she dropped the letter that he just wrote to her just a couple days ago. So. That'll be interesting. That'll be tonight at 8 p.m. Okay, what are we doing today? Well, if you haven't hit the like button, do it now. If you haven't subscribed, do it now. What are you waiting for?
We're hitting the like button. That's what I got from today. You're like, what are we doing today? We are hitting the like button.
We're
Yes.
hitting that like button before I do anything. We're hitting the like button. We're hitting subscribe. And if you like the show, if you like the entertainment, you like what we cover here, make sure you send breadsticks. Breadsticks are always appreciated. Don't send me your ramen money. As usual, only send me your Starbucks money because nobody needs to drink that crap. It makes you fat. It's overpriced. You can send it to me instead. All right. And especially check out what's on the bottom of the screen because this week especially, Cash Apps and Venmos are going to go directly to my travel for Jeff's funeral, which I am very much missing him for this stream. He read the appeal with me. He and I did the appeal together when David Gingras dropped that piece of garbage, and we had a lot of fun with this button.
Say Rule 26 one more time, motherfucker.
And I have a feeling that it's coming back in this filing. We will have occasion to use it again. But if you do want to watch the appeal reading, I did that with Legal Vices on my channel and his channel, and you can see that there. So anything that comes into Cash App and Venmo this week will be helping me with some travel costs as I go to Utah to say goodbye to our friend. Dang. Okay, I don't want to talk about that. Nope. Do not want to talk about that or I'm going to ruin my makeup and I think it looks good today. All right. There's a part of me, Tug, that feels like I'm not going to believe it's real until I see him. And that's good because I still don't. I still don't feel it's real. I still feel like I'm in denial. All right. Here we go. In the Court of Appeals in the state of Arizona, Division 2. And why don't we do pages? You want to do that, Tug?
Yeah, that sounds fun. Mm-hmm.
Okay. All right. So this has been written. By the way, we have a new writer of this appellate reply is Marcus Reisinger. Now, you'll remember Marcus. He has always been the appeal guy in Woodnick's office. Gregg Woodnick doesn't usually do appeals. They have a separate lawyer for that. And this would be his. Now, we're just going to skip over all the table of contents. So, hey, look, we're already on page 6. Amazing. I should have made a bingo card.
Man, we're reading so fast today. That's amazing.
I know. I know. Oh, Flux, good to see you. There's a Flux sighting in the chat. It has been hard without him, Flux. I agree with you completely. And I don't know. I feel like it's not going to get any easier. All right. Statement of the case. I will begin. You will take the next. We will trade off page by page. This somewhat unusual case. You can say that again. This somewhat unusual case comes before the Court of Appeals following paternity litigation without a proven pregnancy or even credible evidence of intercourse that could have produced one.
She lied?
Yep. Although the opening brief makes sweeping claims of jurisdictional deficiency and judicial misconduct, the core issue is whether a person may file a petition alleging paternity, fail to provide objectively sufficient proof of pregnancy, tamper with evidence, what? And lie under oath.
She lied?
And opt out of the litigation consequence-free. I love this opening. This is exactly...
That's hard hitting. That's the way it should be.
Exactly right. This is exactly what happened. The trial court determined, and this is how he feels. Jingy feels, baby Jingy thinks that Laura should be able to skate and do what she did and walk away with absolutely zero consequences. And we disagree. The trial court determined that Laura Owens could not do those things without making Clayton Echard whole for the fees he incurred to defend himself. This appeal followed. Yeah, statement of facts and procedural history. Now, folks, if you are not familiar with this case, this is going to get you all caught up right here. Statement of facts. So, yeah, buckle up because it's going to be interesting. Because this court generally defers to the findings of fact of the trial court, and most of the factual findings are not challenged, Clayton will provide a non-comprehensive summary of the facts and history, and we have a footnote. Never skip the footnotes, people, when you're reading legal documents. That's where all the good stuff is.
Yeah, you might even get a denial or 3.
You might even be denied in a footnote by a judge.
I've never seen that until recently, but hey, that does happen.
You also might even not be able to avoid them in a deposition when you're trying desperately to avoid footnotes. Tug and I have been reading.
Amazing.
We've been reading the What the Hales Pensacola deposition of Jeremy Hales, and it's unbelievable. So if you've missed that, make sure you go back and listen. Footnote number 1 says, Laura filed various motions, many motions, at the beginning of the action that were dismissed by the court. Motion to communicate, expedited, easy for you to say, expedited motion to seal, etc. For the sake of conciseness, these filings are not part of the summary, but are present in the under advisement ruling issued June 17th. Okay. Additionally, although there were 2 companion actions, an order of protection and an injunction against, that would be you.
Harassment that occurred during the underlying paternity action. See footnote number 2.
There you go.
Namely, a protective order action brought by Laura against Clayton, which was heard by Judge Duty, the best name ever for the decision that he made, for sure.
Remember Judge Duty was trying to look. Well, I can't read it.
If I read it at an angle, does it make more sense? Yeah. And an injunction against harassment brought by Clayton against Laura, which was heard in 2 settings before a judge. That almost looks like a typo to me.
Just call her Judge G. It's Gail Katzis. Gail Katzis.
Oh, man. It sounds like a video game from the 80s, you know?
It does.
You know? Oh, man, I love this game, Gail Katzis. Yeah. Both actions were made part of the record for the paternity action by the trial judge. All right, we're back.
Oh, okay. All right.
Okay, so go back. That occurred during the underlying paternity action. They are only discussed to the extent relevant to the judgment in this case. See, blah, blah, blah. On May 20th, 2023, Laura performed ye old oral.
We call it oral arguments here.
She made oral arguments on Clayton. On
we have
August
a footnote.
1st, 2023.
We're
scrolling. Save us.
Footnote number 3.
I was like, what's happening?
Kind of like when I drive you around on Google Earth. It's very similar. Did you take your Dramamine before you came aboard? Did you?
It's slipping. It's falling. I'm falling down the page. Laura alleged there was non-consensual sexual intercourse, but this was, quote, not alleged initially in the court filings. It was not alleged until 2024. Yes, so she called him an ARPist. So let's be.
It wasn't alleged until 2024, as if it never happened. Of all the things that never happened, that one never happened the most. Okay, there we go. You're on here on August 1.
On August 1st, 2023, Laura filed a petition to establish paternity, legal decision-making, parenting time, and child support, alleging she was pregnant with Clayton's twins after the May 20th sexual encounter. The trial court found the sexual conduct, I messed that, I don't even know, did not result in pregnancy.
Oh my God, she's back. It's fake Laura Owens. Thanks for the 5. Sorry I've been gone. These fake triplets are a handful. I'm in my 10th trimester.
That's got to be rough.
We missed you. We missed you, Laura. We missed you very much.
So HCG tests. Laura had a medical history of diagnosed conditions that affect the likelihood of pregnancy, including epilepsy, polycystic ovarian syndrome, and ovarian cancer. Laura, quote, has had PCOS since the age of 17 and does not have a regular menstrual cycle, unquote. On May 31st, 2023, Laura allegedly took an at-home pregnancy test, which apparently showed the presence of HCG. Let's just skip there.
Yeah, let's skip all. No, go ahead. Say it, Tug. Pronounce it. I really want to hear you.
It's his. There's something about a human.
Here, wait. I have a button for that.
America is a nation that can be defined in a single word. I was going to excuse me.
There you go.
The presence of HCG in her urine. This was the 4th time she had tested positive for
pregnancy in her lifetime. All prior alleged fathers believed she fabricated the pregnancy and doctored medical records. Wow. Damning. On June 1st and June 19th, 2023, additional urine tests showed the presence of HCG, one at Banner Urgent Care and another completed at Clayton's home. On its own, the presence of HCG is not determinative of pregnancy, which requires confirmation from a medical provider through an ultrasound or other verifiable objective evidence. Example, giving birth.
Giving birth, yeah,
that would do it.
Yeah.
Alternative reasons for the presence of HCG in blood and urine include epilepsy medications, anxiety medication, clozapine, horse urine, fertility treatments, IVF,
horse urine,
trigger shots, and cancer. On October 16th, 2023, Laura allegedly obtained a blood draw, which indicated her HC levels were 102. That's 102. Laura changed the results to reflect levels of 102,000. Both medical experts, Dr. Deans and Dr. Medchill, confirmed that an HCG level of 102 indicates a non-viable pregnancy. Even with this information, on October 18th.
Think about that first person they figured out, hey, horse urine affects your HCG. Like, wait, how did that happen again?
No, I think what they mean is you can use horse urine to get a positive HCG. So you can dip.
Somebody's like, if you drink enough, maybe we
Yeah,
can.
I don't think anybody's drinking it, but if you dip the stick in it, it tests positive.
You never know. There's some pretty fascinating people out in the world. Let's just say
this is true. This is true. Bruce in Oregon. So much urine in this case. I need a towel. We're swimming in it over here, folks. We're just swimming in it. Oh, gross. Get your water wings out.
Gross, man. I'm glad I wear a mask. Oh,
all right. Where were we? Even with this information, on October 18th, 2023, Laura requested pre-decree mediation, claiming that Clayton acts as if the unborn children don't exist, despite a preponderance of the evidence. Additionally, on October 24th and November 2, 2024, Laura testified before Judge Galketsis that she had a high-risk pregnancy, was 100% 24 weeks pregnant, and was due on February 14th, Valentine's Day, and was being actively seen. Go ahead.
Dr. McCool. That is a good name, by the way. And Dr. Higley, who she saw last Friday. On October 25th, 2023, Laura testified before the Judge Duty regarding the validity of the sonograms sent to Clayton that she believed she was having fraternal twins, one boy and one girl. So sonograms, miscarriage.
Footnote number 4.
Oh, wait, footnote. My bad. By agreement of both parties, the trial court took notice of the proceedings in which is Laura's order of protection against Clayton and in Clayton's injunction against harassment against Laura, and reviewed the FTR recordings of the evidentiary hearings.
And those hearings were
They were something. They were indeed something.
They were wild.
Yeah.
The facial expressions alone should go down in history. Like, I mean, it was just like a silent movie. It's fantastic.
It was. She could have been. She could have made silent horror films.
It was really, I mean, it's just, I need to go back and watch it again. I mean, it's just, if I had more time, I would be playing the What the Hales Owens and Owens v. Echard court cases on a loop in my house just all the time.
Could you imagine both of those? Like they're questioning each other. Oh, that would be amazing. You know, they're competing with one another.
Mm-hmm.
You're not a nice person. Laura Owens is like,
wait. This is how it would be.
You are not a nice person. I'm the best.
What?
I have anxiety over the roof.
I think that would be magical. So on March 1st, 2024.
I love this headline. You got to read the headline.
Sonograms, miscarriage, and medical providers. On March 1st.
It's almost like the Wizard of Oz. Lions and tigers and bears. Oh my.
Lions and tigers
Sonograms,
and frauds.
miscarriages,
Oh my.
and medical providers. Oh my.
Laura testified that she obtained a sonogram at Planned Parenthood that confirmed the presence of twins, July 2023, and that she modified the image to falsely attribute it to Smile by altering the heading, the name, and the date of the sonogram. Laura alleged she obtained the original sonogram, quote unquote, anonymously at Planned Parenthood, Mission Viejo, July 7th, 2023. Planned Parenthood does not accept patients using an alias. Patients are required to provide a government-issued form of identification. So May 15th, 2024, Laura claimed the original sonogram was from... Huh?
You said May.
Oh,
April.
My bad. Man, I'm half awake. I was up all night, by the way. So
I know. Well, now it's your turn with the sick kids. I had it last week. Now it's your turn. Mine are all thank God, they're all back to school. So
luckily, Megan set this later because otherwise it wouldn't have worked. I'd been like, oh, but my brain is still a little. It's better. But
it's okay.
God knows what it might add.
It's all right. That's why I'm here to correct you. Just kidding.
On April 15, 2024, Laura claimed is that your birthday?
It is. It is.
Look at that. I remember.
Yeah, because ours, like, hey, I'll never forget yours. We're a month apart exactly.
I know, that's what it is. Like I was like, oh man. So on your birthday, she claimed the original sonogram was from a visit to Planned Parenthood, Costa Mesa, July 2nd, 2023. Now on March 18th, and April 17th, 2024, Clayton sent HIPAA record requests to Planned Parenthood in Orange and San Bernardino counties, which denied having any sonogram records.
For Laura, and noted the alleged sonogram was not consistent with ultrasound images generated by their practice. Whoops. Then, for the first time at trial, on June 10th, 2024, Laura testified that the sonogram was from a visit to Planned Parenthood Los Angeles on July 2nd, 2023. Laura claimed this was the reason Clayton was unable to obtain any records from the Planned Parenthood visits she previously disclosed. They were false statements. So, in other words, what was that again?
She lied.
Right. On February 21st, 2024, during a status conference, Laura stated she has miscarried sometime in September or October of 2023. On March 1, 2024, Laura alleged she passed 2 sacs, which appeared to have a membrane.
This will get awkward.
In September or October of 2023. Laura later claimed she passed the tissue on July 23rd, 2023. Laura alleges did not experience heavy bleeding and spoke with an online telehealth provider, as all women do when they're going through a miscarriage.
Yes. Oh no!
They go online to a chat. They talk to a chat bot, and she spoke with a telehealth provider who found it. And by the way, that wasn't a telehealth provider; it was a miscarriage hotline, literally a chat bot, who found it hard to tell whether Laura had a miscarriage and advised her to seek in-person care, which she did not do.
Another thing women in crisis do too. Oh my God, you need to get to the hospital. Oh yeah, maybe not.
Just call the chatbot.
I gotta make some banana bread. Sorry.
I'm just gonna text the chatbot. It'll be fine. Laura alleges she took additional HCG tests, more urine. Bruce, get the umbrella out. which were positive. Laura made 4 appointments with Dr. McCool, a maternal fetal medicine specialist, in the month of August 2023.
Did you say Bruce?
I did.
Yeah, I was thinking more along the lines. Well, call the wrong person, they might come with a funnel.
Gross. I was talking about Bruce from Oregon, not the other one.
Yeah.
We're thinking about suing Bruce for taking Bruce from Oregon's name and sullying it. You know, we're contemplating hiring an attorney.
I know, man. What's with these people? They take legitimately decent names, and it's like they roll them in crap.
It's terrible, and I feel that Bruce from Oregon has been defamed by this.
Exactly. Would you like a cow patty with that? It's like, no, I wouldn't. I've been wearing this name just fine until you came along, sir.
Oh, Lord. All right. Laura made 4 appointments. Yep, we got that. Laura rescheduled 3 of the appointments and canceled the 4th. Mm-hmm.
Yep. So in the action before Judge video game on October 24th, 2023 and November 2nd, 2023, Laura testified she actively had a high-risk pregnancy, was 24 weeks pregnant and due February 14th, 2024, and was being seen by Dr. McCool, Dr. Higley, who she saw last Friday. Yes, indeed. Remember all of that for sure. Wow, when that fell apart, it fell apart bad, didn't it?
It sure did.
On October 24th, 2023, October 25th, and November 2nd, Laura was seen standing and rubbing what appeared to be a swollen abdomen in the OOP and IAH hearings. Remember that one well, too.
With the belly that started like at where her boob should be. Yeah.
Yep. That's normal in pregnancies. You just turn into a swollen ball.
And you can move it around and adjust it when you need to.
Man, could you imagine if that were like real life? You could actually adjust it.
Oh, that would have been great. You know how many times I was trying to remove a foot from my bladder? Like I would be in there poking and prodding and like pushing the baby and like, no.
That's gotta be weird for you ladies. Cause I mean, just being told, hey, right here's the baby, and I can feel a foot. I'm like, oh, that's really weird.
Oh, it's incredibly weird, especially like when elbows start popping through it, like the elbow will come out and you can like grab a little arm almost. It's crazy. Speaking of weird things, Dave Neal is coming to the program. How are you?
Things,
listen, I didn't know you were going to have your clavicles out for us. What's going on Monday?
I'm back. I like my clavicles. I think it's one of the thinnest parts of my body. So I like to.
Isn't a good clavicle can get you laid in your single days? Isn't it? Those little signs of vitality we cling on to. A little deltoid pops out.
It's true. I haven't been on camera in a while. I thought I might as well fancy it up a bit. Your recent videos, Dave, with your recent camera work, can I just say, what the actual hell is going on over there? You got drones. And
that's it. It looked like you got drones circling you, man.
I was looking for the umbrella guy. I was flying drones through the woods trying to find a down tree. I couldn't find you.
That video you made about with the sledding is so beautiful. It's incredibly beautiful.
Oh, that's kind. Job. Those are love letters to my family, and if people like them, great. But if they don't, it's for us. You know what I mean?
They're beautiful. Absolutely beautiful. And I especially love the overhead view of your neighborhood at twilight. My goodness.
I know. Wasn't that, winter is so bleak, but when the snow hits the trees, you're like, all right, this is what we paid for.
Yeah. It was incredible. Tug, I got to send you a link to that. You probably don't have it because it's on Tasha's channel. But Dave just put out this beautiful video of sledding in the Tennessee snow with his drone. And you're just too pro for me these days, Dave. I feel like you're leaving me behind.
But what's funny is like you were like, oh, I love the video you shot. And it was the easiest one I made, like a GoPro on a selfie stick. And you were like, who is the camera guy? I was holding a stick.
But you did it so well. I couldn't tell except for that one reflection in the door. You can't tell which hand you're holding it in. Like I
think I'll do that more often because it's nice to get fresh air. And I hate being inside all day. So maybe I'll do that more often.
Yeah, I loved it. I thought it was really interesting to watch, and you do really well. You didn't get off script at all. You're amazing with that.
Oh,
The
thanks.
hair is looking pretty good too. Boy, you know, Dave's like growing his hair out. He's trying to take my title.
You know,
for the best hair on YouTube.
we're only friends so we can compliment each other. We're like two people
Is that what it is? Hair
leaning up
compliment.
against each other.
Well, we are taking turns reading through this appeal reply. And so how about you take the next page after this one, Dave? Does that sound
Sure.
good to you?
Yeah, absolutely.
All right. Where were you, Tog?
I don't know a lot. Oh yeah, I mean Laura's records. What would be? Yeah,
Here, I
Laura's
think you're-
records.
yeah.
Laura's records show that she was never treated by Dr. McCool, Dr. Higley, or any other in-person obstetrician or gynecologist. On November 14th, 2023, Laura took 2 pregnancy tests from MomDoc, which confirmed she was not pregnant. Disclosed by Clayton Dunn, 2/23/2024. Paternity testing, boy and girl twins, and procedural history. On August 1st, 2023, Laura filed her petition to establish, alleging she was pregnant with twins. On August 21st, 2023, Clayton filed a pro per answer denying that Laura was pregnant with his children. Man, give me a second. Let me get a little more caffeine in me. Give me 1 minute.
Poor Tug was up all night with a sick kid.
Oh, the worst.
By the way, Augie, your baby Augie, that red hair, I can't get over it. He's so cute.
He wakes up smiling at me like there's no better thing in the world. But yeah, I mean, like he was, my son was sick last weekend and we had to do the snot sucker.
Oh,
you know?
Oh man, I hate that. Yeah.
It's like, but if you don't do it, then the kid's miserable because he can't breastfeed and breathe out of his nose at the same time. So,
but he hates that, I'm sure. They scream. They scream.
oh, he's, and I'm like, you know,
and then you got to figure out how to hold their head still so they're not doing this because they will fight you. They will, and then you know you're worried that the thing is going to hurt their little nose. Do you do the one where you actually suck through it, or do you do the squeezy one?
The squeezy one's for like the minor leagues, and then the heavy duty one, yeah, it's like a tube with a sponge in the middle, the Frida, and it worked. My Tosh was like, "Ew, that's gross." I was like, "I'm gonna suck the snot out of this kid's nose."
Yeah,
and
no, it works. It works.
It's like when you're eating a milkshake and you're down to the final, you got to like scoop the final bit out.
Listen, parenting is not for the weak stomach.
It is definitely not.
I had an incident once where my daughter, she spewed shrimp vomit all over from the top bunk. She had eaten shrimp, and then it all came up at 2 a.m. It landed on her sister, all over the floor, and some of it got on me. It was the most heinous thing in the world. She never ate shrimp again. All of us never wanted to look at it again. It was hideous. But I mean, this is parenting, man. You're going to have stories. You're going to have war stories.
Yeah, no complaints. You know, like I just walk them in. If there's a bad, you know, if some bad disaster, some, you know, blowout breaches the levees, I walk them straight into the shower and we go to town.
Yeah, you gotta roll with it, man. Yeah.
Mm-hmm.
All right, here we go. I got a little more caffeine there. Here we go. Answer denying that Laura was pregnant with his children, denying intercourse, denying paternity, and requesting an award of attorney fees pursuant to. Now, Clayton moved to amend his response on December 12th, 2023, and file the amended response January 26, 2024.
All right, Dave, it's all you.
Oh, here we go. On October 2nd, 2023, Clayton and Laura participated in paternity testing with Ravgen. On October 6, 2023, the results indicated little to no fetal DNA. On October 18th.
Whoa, that's sorry. Go ahead.
Is that your no fetal DNA button?
Yep, that's my no. Exactly.
No fetal DNA. On October 18th, after Laura learned she had no viable pregnancy via blood test on October 16th, Laura requested pre-decree mediation, claiming that Clayton acts as if the unborn children don't exist, despite a preponderance of the evidence. Recall that on November 2nd, 2023, Laura testified to being 24 weeks pregnant with twins and due on Valentine's Day 2024, weeks after she already knew she was not pregnant, according to her narrative. On December 6, 2023, the results of another Ravgen paternity test indicated little to no fetal DNA. The results for a third test were lost in transit. You hate
So
when
sad.
that happens.
Hate when that happens. Yeah, man, that's so convenient.
On December 12th, 2023, Clayton filed a notice of filing affidavit of non-paternity. On December 28th, 2023, Laura filed a motion to dismiss petition to establish paternity, legal decision-making, parenting time, and child support with prejudice, alleging she was not now pregnant with respondent's children. The court denies the motion to dismiss on Valentine's Day because the issues of attorney fees, costs, and sanctions remained.
You know what? I never noticed that. I never noticed that it was the same, her due date that motion got dismissed. That is fate right there.
The old due date, which of course is now Mike Maricini's due date.
Is it really?
I mean, it's like within a week or so. Yeah.
Oh, wow.
Amazing. It's all the same to me. Mike Maricini's real child. Beautiful family.
Right.
Beautiful family.
Yes, beautiful family. His wife is so pretty, she's hard to look at.
It was hard to have a conversation with both of them. They were both tall, so I was looking up like a child trying to get their parents' approval. Like
I know.
Yeah.
Very
anyhow,
good-looking
and then there
couple.
we were, just blobs, just
in our hats.
She was like, when I met her, she was like, I feel like I could give you a hug. I was like, you get in here. Come on. We're family now. I don't know about you guys, but when my family is people that I defend in fake paternity cases. Okay. I didn't know that, but I know now. On January 2nd, 2024, Laura filed an expedited motion to quash deposition, which the court denied after briefing. On January 3rd, 2024. Do I keep going?
No, I'm going to take the next one. Clayton filed a response objection to Laura's motion to dismiss and a motion for sanctions pursuant, to Rule 26.
Hey, Rule 26, one more time, motherfucker.
Laura did not appear for her first scheduled deposition. I forgot all about that. This is great. We're going back over this because I forgot she didn't show up.
She was busy. She had a busy day.
This woman. On January 17th, 2024, Laura filed a motion for confidentiality and preliminary protective order referencing a miscarriage for the first time. On February 2nd, 2024, Laura deposed Clayton. During the status conference on February 21st, Laura claimed she miscarried in September or October. With consent of the parties, the court advised it would review the IAH and the OOP hearings, treat the motion to dismiss as a request for attorney's fees equally, and hear evidence and testimony as it applies to sanctions and attorney's fees and costs dating back to the filing of the petition. All pleadings filed within the Maricopa County Superior Court. On February 27th, 2024, a few days before her rescheduled deposition, Laura sent a letter to Clayton indicating that she would sue him for approximately $1.4 million unless he agreed to unconditionally dismiss the paternity action. I mean, this case is wild. And this is a great day for you to be here if you've never heard about it, because this is a review of the entire thing.
Yeah, it's a good breakdown, too.
Yeah, it is. Clayton deposed Laura on March 1st, 2024. For the first time, Laura stated she passed 2 sacs, which appeared to have a membrane.
What?
In September or October of 2023, and took a picture of them.
This will get awkward.
Laura later claimed she passed the tissue on July 23rd, 2023. On March. And Tug, you can start on March.
I'm dealing with a writer real quick.
A writer? Okay, Dave, take over.
On March 11th, 2024, Clayton filed a motion to compel Laura to disclose the alleged Planned Parenthood records. The image of the 2 sacs, the name of the telehealth provider she spoke to on the day of the alleged miscarriage, and a file from a 2014 paternity case. On March 25th, 2024, Clayton filed a motion for joint hearing and an amended motion for relief from judgment based on fraud, requesting the court take additional evidence against the OOP Laura filed against him on October 6, 2023. The latter motion was granted on May 21st, 2024, with the court reiterating it would view the records from both the IAH OOP hearings to rule out the validity of the OOP and any award of attorney's fees at trial. On April 3rd, 2024, Clayton withdrew his prior motion for Rule 26 sanctions. On April 4th, 2024, Laura filed a notice of non-objection. The court accepted the withdrawal on April 4th, 2024, but did not distribute the order until May 16th due to a clerical error.
Hold on. So this is interesting. So Baby Jingy is always complaining that the court did something wrong because it accepted the withdrawal but didn't distribute the order. But it's just a 2-day thing. Like what even? Oh no, I guess it's 2 weeks. Sorry, from April 4th to May 16th, maybe 3 weeks. Okay, didn't distribute the order. Okay, fine, whatever. I'm just trying to figure out what he's complaining about. All right, go ahead, Dave.
On April 8th, 2024, Laura filed a motion to compel lunch and for alternative relief, denied. April 30th. On April 12th, Laura moved the court to take judicial notice of Laura's prior lawsuit against another person, Gigi, whom she also alleged impregnated her. On April 30th, 2024, Laura filed a motion in limine, seeking to preclude the testimony of 3 other men whom Laura alleged impregnated her in the past.
Tug, you back?
I'm back.
All right.
May 10th, 2024.
Wait,
Laura,
stop. Motion denied.
Denied. Sit down.
Oh,
There we
my
go.
bad. Motion denied. My bad.
We can't forget that. We have a button for it. All right.
Never. May 10th, 2024. Laura filed a motion for judgment on the pleadings and renewed motion to dismiss, which the court deemed moot and therefore denied. May 28th, 2024. Wow, seemed like a lot of denials, huh?
A lot. Yeah.
June 3rd, 2024, Laura's prior counsel filed an ethical Rule 3.3 notice of candor, indicating that their statement at the status conference that Miss Owens has not lied in this case was no longer true, considering Miss Owens' deposition on March 1st, 2024.
Oh boy, good old Corey. We miss you, Corey. You know, I hope whatever you're doing out there, Corey. I hope Corey Keith. I hope you're doing well. You did the right thing. You're a stand-up guy, stand-up dude. I would hire Corey. He did the right thing.
Yes, more lawyers need to actually do that when they find out their clients are lying.
Yep.
Trial, final judgment, and post-trial filings. From May to June 2024, the parties filed various other motions, requests, and statements in preparation for trial. The court held an evidentiary hearing June 10th, 2024, issued its final judgment in the form of an under advisement ruling, a UAR, June 18th, 2024. The UAR summarizes the history, the court's finding, the legal analysis of various issues presented, and the relief awarded with substantial detail. As to paternity, the court found it could not establish Laura was pregnant as a threshold matter, then further elaborated that Laura failed to meet the burden of proving Clayton was the father of the alleged pregnancy. The court granted Clayton's request for a finding of non-paternity.
She lied?
Indeed.
The court also awarded Clayton attorney's fees and costs based upon the law and with a 2-page explanation of the findings supporting the award. The court found Laura initiated the litigation without basis or merit, that her petition was premature at best and fraudulent at worst, and that Laura's explanation for requesting mediation after she already knew there was no viable pregnancy was disingenuous, misleading to the court, and perjurous.
She lied?
The court also found Laura repetitively failed to comply with Rule 49 by altering HCG tests results, an ultrasound, and a sonogram, and falsely reporting facts about her alleged Planned Parenthood visits, including a brand new disclosure at trial that she sought care at Planned Parenthood in Los Angeles, despite prior assertions and discovery being directed to other Planned Parenthood locations and entities. The court found Laura filed her petition in bad faith, that it was not grounded in fact or based on law, and that it was for an improper purpose.
What?
The The court found Laura provided false testimony.
She lied.
In all three cases against Clayton and unreasonably threatened to sue him for $1.4 million in collateral allegations unless he agreed to dismiss the action Laura initiated. Lastly, the court found Laura knowingly presented a false claim and knowingly violated a court order compelling disclosure or discovery. I forgot all about that. Footnote 5, to be clear, Laura does not challenge these findings on appeal. Instead, she asserts that the court should have dismissed the case before she engaged in most of these behaviors, so they can simply be ignored. Oh, yes, that's exactly what they're trying to say.
Yep, that is exactly it.
After the ruling on July 8th, 2024, Laura filed a notice of change of judge for cause, memorandum and affidavit in support, alleging the trial judge conducted an independent investigation into the facts via social media. After briefing, presiding family court judge Honorable Aranda Fisk denied the notice, finding Laura did not present a prima facie case for bias or prejudice, and if such error occurred, it was harmless given the overall weight of evidence supporting the judgment. The same day, Clayton filed his application for attorney's fees and costs, which was granted on August 16th, 2024, after a timely response and reply. On July 12th, 2024, Laura filed a motion to vacate judgment, motion for new trial, alternatively, motion to alter, amend judgment, motion for leave to exceed page limits, which the court denied on September 9th, 2024.
Denied. Sit down.
On September 5th, 2024, Laura appealed from the order, application for attorney's fees and costs seeking review of all prior non-appealable interlocutory decisions, orders and rulings made by the trial court, and she filed an amended notice to include the trial court's denial of Laura's motion to alter amend. Laura cites from final judge appeal from an order affecting a substantial right that prevents final judgment from being entered, order refusing a new trial for appellate jurisdiction.
Statement of the issues. Laura's opening brief argues 5 issues. So we got 5 arguments. Further references to these issues presented in the opening brief will be to the issue numbers. So jurisdiction. Are we going to read a whole jurisdictional argument?
Yes.
Oh, well.
Sorry.
This court has an independent duty to determine whether it has jurisdiction to consider the issue raised in an appeal. The appellant court's jurisdiction is purely by statute. So they give different statutes. Intermediate appeal jurisdiction is only as provided by law. Another instance, listing instances in which an appeal may be taken to the Court of Appeals for a superior court. The opening brief cites, again, you have your assignment there, appeal from final judgment. A3, appeal from an order affecting a substantial right that prevents final judgment. And A5A, order refusing a new trial. Most of these issues Laura presents for review do not arise from the final judgment. Issues 1, 3, 4, and 5 all arise from her arguments that the trial court should have granted one of Laura's pre-trial motions to dismiss. Like you said, before she made a fool of herself, she shouldn't have been given the opportunity.
Or at least more of a fool of herself. Yeah.
Yes, I lied and I faked all of this, but I should have never been given the chance. What an argument.
Well, it's like how she says that she only sent me fake evidence because I was cyberbullying her. Like everything is somebody else's fault. You know what I mean?
Yeah. Mm-hmm. That's amazing. Denial of a motion to dismiss cannot be directly appealed, but it can be reviewed on appeal from a final judgment only if it is an immediate order involving the merits of the action and necessarily affecting the judgment.
Argument. The opening brief does not prove error or establish grounds for reversal. The court awarded Clayton attorney's fees as a statutory remedy, not a Rule 26 sanction.
Say Rule 26 one more time, motherfucker.
Making most of Laura's arguments categorically inopposite. There is no safe harbor provision to avail a party whose conduct falls short of their duties under Article 49. who knowingly presents a false claim or violates a court order compelling disclosure or discovery under the law or acts unreasonably under the law, the opening brief freely admits that Rule 26 safe harbor applies only to the conduct that allegedly violated that rule. For that reason, Rule 26's safe harbor must be construed as not only shielding litigants from punishment under Rule 26, but also from punishment under any authority to the extent the punishment is based on the same conduct that allegedly violated Rule 26. Issues 1, 3, 4, and 5 all rest on the same mistaken assignment of error, and they must fail for the same reason. The court did not err by denying Laura's motions to dismiss and acted within its authority to award Clayton attorney fees under Title 25 statutes. Moreover, Laura has not proven reversible error in the form of misconduct by the trial judge as alleged under Issue 2. Clayton contests the sufficiency of the evidence Laura presents to establish such error occurred. Even if those facts are accepted as both true and sufficient, the standard in Title 25 cases is harmless error.
Not structural error. An erroneous finding regarding a collateral fact used only for impeachment is harmless given the overall weight of the evidence in this case. For these reasons, the court should affirm Issue 1. The court did not sanction Laura under Rule 26 and did not err by awarding Clayton attorney's fees under other authorities. Standard of review. Generally, an award of sanctions is reviewed for abuse of discretion. And
this is the argument that we actually made, that I said, was that even if the argument was that the judge knew when Planned Parenthood was open or closed, given that, let's just give him that she looked it up herself, that one fact would change nothing in this case. It would not change that Laura lied multiple times, that she fabricated evidence. It would have nothing. It's harmless error.
By the way, I got a very interesting email from a lawyer. You might remember a month ago, I had a retired lawyer send me an email that a lot of people liked. So he wrote me back. So for everyone who's reading this, you're gonna want to watch him after, because he made an interesting argument that the whole Planned Parenthood thing could have just been information that Judge Mata was putting in there for reasons why she would recommend prosecution from the county prosecutors or recommend investigation. So just because that was in there doesn't mean that's the full finding. That's just added information.
Oh, that's interesting.
Yeah, it was an interesting kind of argument that he said, well, maybe she should have made sure to separate that information, but, it's like, here's all the evidence we have. And because of that, she needs to be prosecuted. So the judge wouldn't want to recommend investigation without knowing for sure that she was lying under oath.
Mm-hmm. Interesting.
Am I going here? All right. B. Yeah. Court did not sanction Laura under Rule 26. The first threshold of this argument is whether the trial court sanctioned Laura under Rule 26 at all. To even consider Laura's argument, which she repeatedly asserts disposes of the entire case on appeal, this court must first entertain a most meaningless hypothetical. What if the trial court sanctioned Laura under Rule 26 and no other authority, although Clayton moved for Rule 26 sanctions based on Laura's court filing relatively early in the case? He withdrew that motion on April 3rd with no objection by Laura and proceeded with other claims for relief under ARS 25-324. By the time of trial in June, there had not been a pending Rule 26 motion for over 2 months.
Right. And he just spends his entire freaking appeal whining about Rule 26.
Hey, Rule 26 one long time.
There was no pending appeal. There was no pending motion for Rule 26. That's what Jeff and I were pounding the table on the last time when we read the appeal. It's like, dude, there is no Rule 26 motion. Stop saying it. Ugh.
After Clayton withdrew the motion, Laura argued in multiple filings in that trial that the court could not award sanctions under Rule 26.
Exactly. All right.
Laura filed her motion to dismiss after Clayton answered the suit, but before the motion for Rule 26 sanctions. By the time of her second motion to dismiss, Clayton had already withdrawn the motion a month earlier, largely to avoid unnecessary satellite litigation. Laura threatened to bring over the safe harbor issue.
Yep.
She raised her arguments over Rule 26 again in her pretrial statement and at trial. The court included detailed findings about Rule 26 issue in the UAR, but the court ultimately only awarded attorney fees and costs under Title 25 statutes based on relative financial positions, unreasonable positions, and discovery and disclosure violations. The trial court did not rely on Rule 26 at all, despite Laura making it the centerpiece of her position in the proceedings. Therefore,
exactly.
That's a mess.
Actually, a total mess.
Therefore, to the extent Laura argues Rule 26 controls the outcome, the issue is simply moot.
That is what me and Jeff said. We said it's moot. It makes no sense at all to even bring it up because there's no Rule 26 motion.
No way, man. Such a quality lawyer, you must be mistaken. There's no way that
Jeff would have loved this. Jeff would have loved this reply because this is exactly what he said. This is exactly what how he described this.
So the parties can debate various sub-issues, e.g. whether ARFLP 26, ARCP 11, FRCP 11 have identical requirements / are governed by the same law, whether Clayton complied with Rule 26, whether Rule 26 requires strict compliance, whether non-compliance precludes an award sua sponte, whether a remedial award of attorney fees and costs even qualifies as a sanction, and so on.
But the inconvenient truth is that none of these questions are actually before this court. That's a problem.
Yeah.
Laura's reliance on her interpretation of Rule 26 is misplaced. Laura, like every other Title 25 litigant, knew she may be ordered to pay Clayton's attorney's fees when she filed the petition, received notice again when he requested fees in his response under this law, and was reminded in nearly every subsequent filing and hearing thereafter. Even if Clayton never mentioned Rule 26 whatsoever, statutory remedies were always available. Laura asks this court to award her carte blanche because of a Rule 26 motion having once been filed. Her reading of Rule 26 would turn the safe harbor into a formalistic sinkhole and do damage to the statutory attorney fees scheme that has nothing to do with the signing of filings. Rule 26 does not apply to awards given under ARS 25-324, 25-415, or 25-809. And if you want to know what those are, we went over them on Jeff's channel when we read the appeal. We actually read each one of those and found, we were like, what is this guy even talking about? The judge can award her these fees under each one of these, having nothing to do with Rule 26.
Hey, Rule 26 one long time, motherfucker.
Laura argues the failure to strictly comply with Rule 26 precludes sanctions under any other authority. On its face, nothing in Rule 26 references any of the statutes permitting the court to award attorney fees and costs in Title 25. Award of attorney's fees after considering financial positions and reasonableness. And they're going to go over it right here. So 25-324A says the reasonableness in financial positions. 25-415 says award for false claims or disclosure or discovery violation, a thing she did. ARS 25-809G, functionally identical to 25-324 in paternity proceedings not involving legal decision-making and parenting time. Dave.
Oh, sorry. Laura.
Child support statutes. Yeah, Laura.
I was enjoying your voice so much. Laura relies support statutes. Laura relies mostly on case law interpreting the federal civil rules for the idea that sanctions are not available without invoking Rule 26. But this reading would expand the rule's scope far beyond its language, purpose, and common sense interpretation. To be clear, Rule 26 in its civil corollary, ARCP 11, applies only to the signing of documents filed with the court. By signing a document and filing with the court, the signer certifies that they have conducted a reasonable inquiry and believe the filing is for a proper purpose, warranted by law and supported by facts.
And if you remember, in every motion we ever read, the very last page is that. It's the certification. I certify, and you have to sign it. I certify that everything in this motion is true to the best of my knowledge, right? And then you sign it.
If the document is signed in violation of those requirements, the court may impose a sanction. The remainder of the court describes the procedure for requesting sanctions under this rule. Before filing a motion for sanctions under this rule, the moving party must ... Emphasis added. Rule 26 says nothing about the myriad factors courts consider and whether to award fees in family law action, including financial resources of the parties, reasonableness of positions, discovery and disclosure misconduct, or any other substantive basis for fees awards outside the signing of a document. Laura's argument seems to assume that Rule 26 is the exclusive vehicle to request an award of attorney fees and costs, but there is no authority supporting the interminably broad limitation on the family court's remedial authority. The court's
authority to award fees and other civil actions is far narrower, mostly relying on ARS 12-349, except in certain actions with specific fee statutes, e.g. contract disputes. Of relevance here, ARCP 11's safe harbor provision is also codified in statute. Seeing, quote, attorney fees shall not be assessed if offending party voluntarily dismisses within a reasonable time after learning a claim is unjustified. There is no counterpart to this provision in Title 25. The court must also consider the practical implications of Laura's arguments. Again, seeing when language is ambiguous, consider effects and consequences of differing interpretations. Laura's argument declares that Rule 26, once invoked, affords a party an absolute right to withdraw from litigation with no consequences. That's insane, by the way. That's an insane argument. It must logically follow, then, that the safe harbor opportunity only comes into existence if a party or the court notifies the offender of their intention to seek Rule 26 sanctions. Again, RB argues that sanctions cannot be imposed without a show cause order triggering safe harbor. She further asserts that other laws allowing sanctions no longer apply after a party claims a specific act violated Rule 26, i.e. the act of invoking Rule 26 or alleging a Rule 26 violation makes the rule the exclusive remedy for that conduct.
Assuming arguendo that these assertions are true as to sanctions under Rule 26, Laura asked this court to craft a safe harbor as to all forms of attorney fees awards, notwithstanding their basis in law. Even the federal courts, relying squarely on FRCP 11, do not go this far. See Caracini v. Nation Star Mortgage. Even if safe harbor not given, court could still have imposed sanctions under Rule 11 C3 statute or inherent powers, and that would be the sua sponte powers. Matsumaru v. Sato. Plaintiff will have opportunity to persuade the court that sanctions should not be imposed under other authorities. This argument, if accepted, would assign a talismanic quality to Rule 26. Under Laura's interpretation, the offending filer would have an unconditional right to opt out of the, I like that word, so it's like almost like magical. He means like talismanic, like a talisman, like a magical quality. Like you could use it like garlic against a vampire, basically. You know, you like holy water on the ecosystem. Would assign talismanic quality to Rule 26. Under Laura's interpretation, the offending filer would have an unconditional right to opt out of the litigation, no matter how egregious their conduct or unreasonable their positions, if the opponent invokes the rule. However, if a party never invokes Rule 26, instead pleading a request for attorney's fees under ARS 25-324 or other applicable statutes, then the safe harbor opportunity would never materialize. In the surpassing, I like you again using the word materialize. We have ghost and magical and ghost references here. I like it. because this is all a fantasy in her head. This is a fantasy in Jingy's head that he can get around this.
It's really a fantasy in her throat, but
or tonsils. Not sure. In the surpassing majority of the Title 25 cases, that is exactly what happens. A party reserves the right to request fees under ARS 25324 or 25809G in their responsive pleading and never mentions Rule 26. Rule 26 demands are comparatively rare, as they should be given the narrow scope of the rule. And the court has never interpreted that rule as a necessary or exclusive mechanism for seeking fees in the Title 25 cases. If the court adopts this interpretation, then the
phrase Rule 26 will become the family law equivalent of Beetlejuice or Voldemort or Nye. Words with magical
or knee. We are the knights who say knee. Oh my God, it's a Monty Python reference.
Before my time.
Oh my God, you've never seen the Holy Grail?
Well, I mean, maybe. I don't know. It's just...
You're a comedian who hasn't seen the Monty Python's Holy
Grail?
Grail?
I've seen it. It just does it. I mean, I don't want to get it. I don't want your commenters to find new reasons to hate me, but...
Oh, no. They do not hate you. Chat.
Whatever.
There better not be any Dave Neal hatred in my chat. I will time you out. We're not allowed to hate Dave. That's not okay.
Either way, I appreciate these references here. Words with magical and counterintuitive effects triggered by their mere utterance, invoking Rule 26, would have so little value and so much risk that aggrieved parties would never use it again. Arizona law has long disfavored magic words in exalting. That's a merch shirt. Magic words.
Magic words
with Woodnick's face on it. An exalting form over. I want to see Woodnick with one of those like sorcerer hats. Magic words. with a little wand.
Locals get on that.
Yeah,
locals chat.
Give us 10%.
That would make an amazing advertisement for TV, by the way. We need some magic words.
Magic words. Get your jazz hands and magic words. Exalting form over function, particularly when prioritizing formality, would undercut the court's jurisdiction in a family law matter. Duckstein v. Wolf, interpreting Rule 31, former version of Rule 26, verification requirement as merely procedural, not jurisdictional, when a party violated the rule in a custody case. Former Rule 31 relating to signing of pleadings who abrogated August 3rd, 2018, effective January 1st, 2019. See now ARFLP 26 historical note, ARFLP 24D. Pleadings must be construed to do substantial justice, ARFLP 86. Harmless error standard in Title 25 cases. Duckstein's importance. Duckstein's importance is twofold in this case. Is this a Mighty Ducks season I didn't catch? I don't know. Episode 4, the fake birth, is the only known published case interpreting Rule 26, albeit addressing the verification requirement since moved to another rule. And 2, it interpreted the verification requirement as procedural rather than jurisdictional. In other family law contexts, errors in preliminary procedures must be addressed prior to a resolution on the merits. Sundstrom v. Flatt in Remarriage of Dorman, 198 Arizona 298-303. An appellant will have great difficulty showing. Hey guys, I got to bounce out of here.
Okay.
I'm up on a deadline to get my afternoon rush up. But by the way, the retired judge says it, to summarize, he thinks this is technically perfect, but lacks the killer illustrations he would have given to illustrate how she shat all over the system. But otherwise, he says he liked it.
Excellent. Well, I would love to. I mean, I kind of feel that. I feel like there could have been more. I don't know what do you illustrations, illustrative, kind of words, right? But then again, we still have 20 pages to go. We'll see.
And you could argue that their mockery here is them, mocking how ridiculous she is. Sorry, we don't use magic words, So either way, that's what the judge said. But I think they got a winning hand. But thanks for letting me jump in, and hopefully I'll be back soon.
Everybody go and subscribe to Dave Neal. Make sure you watch the Rush Hour. His podcast is now on YouTube.
Yeah,
and it's very good.
Sleep. It's twice a day for all those that go, but they don't watch Bachelor. It's entertainment news. I got fire updates. I got random.
Oh, he's doing everything.
Stories you'll love or hate. It's all there. 25 minutes each episode, twice a day on YouTube now. Thanks so much.
Thanks, Dave. Good to see you.
Yeah, good to see you. See you, Tug.
And there's no hate for Dave in the chat. Look at everyone loves Dave, and they should, because we can all be friends.
Chat hate poor Dave. Oh man.
Look,
that would be so sad.
Dave always feels he always feels like scared that people in my chat are gonna not like him because of his politics. But I think there's probably a few, but we try to talk those people down from the ledge, because politics is not everything. Friendship and neighborliness and getting along means a lot more. It really does. It really does.
Yeah.
Politics
you should
is
be able
garbage.
to have your own opinions and still be totally 100% right on cases. Come on.
That's right. That's right. And also still 100% friends. You know,
Yeah,
you
well,
can
100%
have disagreements.
a decent human being. I think that matters, you know.
Dave is a totally decent human being. He's one of the best. And I'm thrilled to have him in my life. I love Dave. I'm going to love Dave forever. He's going to be a friend forever. And I don't care who he votes for. I really don't. It doesn't bother me in one bit, because he's funny and he's fun and he has a good heart. And lots of people in this country have different opinions on how to solve things, and that's okay. Granted, or where were we? Prejudice. Let's see. An appellant will have great difficulty showing prejudice from an error in the preliminary verification or screening procedures under 25-411 after hearing has occurred. Oh, you know what? I just thought about something that the retired judge said. So this is kind of dry, right? It's a dry motion. But the appellate court they don't like cute.
Yes. Yeah.
Most judges don't like cute.
Yeah, but especially appellate courts. They're just like, get to the crux of it.
Get to the point. Like, we want to be told in as few words as possible, why is this? Why do you win this? And if you start putting crap in here like hashtag yikes and hashtag me too, you're in trouble with the appellate court. You're in trouble with any judge, really. You shouldn't do that. And to write an appeal or an appeal reply, for entertainment purposes, I think would be a mistake. I think it would be a mistake. It's law and law only. And it's a little dry for those of us who aren't lawyers. But I did really appreciate the Harry Potter and Monty Python references. That was fun.
Well, you also, in courts, like at regular court, you want to stand out. So sometimes you pull all kinds of weird little games and stuff, trying to make everyone notice it. But with appeal, they just want you to get to the point.
They just want you to get to the point. You do not want to piss off appellate court judges. They don't have a lot of time. The appeals court is like all courts are overrun with stuff to do. But the appeals court in particular, they just want to get through it. The Tilted Lawyer, welcome, Omar. Good to see you. Says opposite of Gingras, not over the top theatrical, just does the job. Yeah. I agree. I think it was a wise choice, especially with how many eyeballs are on this case. And also, you don't want to be accused of what Gingras is doing, which is, writing things for the joke of it. Like, I don't know why he thinks he's being cute when he says things like, "Look at me, Daddy. I'm a real judge now." Tee-hee. I mean, you don't want to do that for sure. You want to be a serious lawyer, then write a serious motion. Yeah. We prefer the funny jokes, but still, it's not for us. It's for the
Well, they need to be funny, too. There's a problem there for Gingras.
Yeah. No, there aren't a whole lot of lawyers who are funny. Granted, Laura's position demands strict compliance with Rule 26, not ARS 25-411. But the family divisions have historically conducted their business informally, with greater interest in just outcomes than formality for formality's sake. Laura had notice and an opportunity to be heard, but she wanted notice and an opportunity to unconditionally withdraw after she initiated the litigation and publicly alleged paternity. Clayton testified that Laura contacted his family, acquaintances, employers, national media, and tabloids like The Sun, calling him a deadbeat. The trial court has broad discretion to deny a motion to withdraw a pleading and must award reasonable costs and attorney's fees if it determines a party filed a petition not grounded in fact. And also, I'm glad they brought this up, because Clayton is a public person. This clearly, her filing was meant to embarrass him. She did it as a power play that has to be taken into account with all of her going to the the Sun and the tabloids and TMZ. It had to. Finding no error in the trial court's refusal to dismiss upon petitioner's motion to withdraw pleading under Article 46. And then we have a footnote. Cited for persuasive value under Arizona Supreme Court, whatever, because no other opinion adequately addresses an award of sanctions under Article 26, previously Article 31, after petitioner attempted to withdraw their pleading. A publicly available copy of the decision may be found here. Oh, that would be interesting to read later. I may do that. Let me click on that for, can I do it? Let's see.
Should be able to. It looks like a live link.
It looks like a live link, but I don't know. It's for download, but let me see.
Oh,
I'm going to open it for later. Yeah, here, it's here. I wonder how, it's only 4 pages. Let's see what the crux of it is. We don't care about the story. Let's get to the ruling. Conclusion. Oh, here, the ruling.
Yeah.
Mother argues that the trial court abused its discretion by denying her request for sanctions. We review all aspects of a court decision related to sanctions under Arizona Rule of Family Law Procedure 31 for an abuse of discretion. Considering Arizona Rule of Civil Procedure 11, on which Rule 31 is predicated, as stated in Arizona Family Law 31, Mother argues that Arizona Rule of Family Law Procedure 31A and Procedure 11 and revised statutes required the court to award sanctions in this case, in light of the court's finding that there was nothing vague about the court's order and that father was to pay 70% of child care costs and mother was to pay 30%. This section directs, among other things, that if a court determines that a party filed a petition not grounded in fact or based on law, the court shall award reasonable costs and attorney's fees to other party. Similarly, Procedure 31 is violated when a party or attorney files a pleading or paper and knows or should have known after reasonable inquiry that the claim, he should have known, or defense is legally or factually groundless, or when the paper filed is intended to cause delay, harassment, or some other improper purpose. Father has failed to file an answering brief in this matter. A failure to file an answering brief is equivalent to a confession of error by an appellee. Because the trial court did not award sanctions, we affirm the dismissal of father's petition, but modify the trial court's order to impose a sanction against father and his attorney in the amount of $1,000. So they affirmed the trial court's, affirmed but modified the order. All right, interesting. All right, back up here. In Grow, father petitioned to enforce and clarify a child support order. You can start here at 4.
Mother moved to dismiss the petition and requested sanctions. Father responded and subsequently filed a motion to withdraw his petition with prejudice, stating he did not wish to proceed with his petition. The court granted Mother's motion to dismiss without awarding sanctions. Mother argued under 3111 ARS 25-324 required the court to sanction father. The Court of Appeals agreed. They signing the appellant court modified the trial court's order to impose a sanction against father. The decision makes no indication that father received safe harbor notice, but the court still awarded sanctions. Interesting. Admittedly, Grovey Grow, what a name. Grow. Man, that's a name we needed in the other trial we're covering, with the potted plant judge.
With the judge's potted plant. Potted plant, yeah.
We need some
we should start calling him Judge Ficus.
Judge Ficus, that's amazing. So admittedly, Grovey Grow is not binding precedent and is not procedurally identical to this case, but the appellant court's insistent that Grow be sanctioned despite trying to withdraw his petition illuminates the starkly different legal environment in family law cases since separation from Civil Rules 2006. The court was certainly aware of the concept of safe harbor when it decided Grow in 2018, and the idea that a party has an unequivocal right to withdraw their pleading without consequence is nowhere to be found in that decision. Now, D, Rule 11, case law does not foreclose the court's ability to sanction on its own motion. Even if the court or the trial court had sanctioned Laura only through Rule 26, a counterfactual hypothetical, it still would not have erred. Laura relies primarily on
Federal Rule 11 case law, and we have a footnote. Laura cites Westerkamp v. Mueller, but provides no foundation for citing an unpublished order from the federal district court. Regardless, Westerkamp merely applies the holdings in other cases, Barber and Holgate, the limitations of which are explained herein. Laura also cites Supreme Court Rule 111 in support of Gallagher v. Serrano. But that rule applies to decisions and orders from the Arizona Supreme Court and Arizona Court of Appeals. Appellee is unaware of any authority permitting citation to trial court orders. Like Westerkamp, Gallagher merely summarizes other cases. That's interesting. Where were we? It is true that Arizona's civil rules are modeled on the federal rules of civil procedure, and the family law rules were modeled on the state civil rules, but there are numerous important differences in the present language. Accordingly, the ARCPs only apply when expressly incorporated into the family law rules, and case law, interpreting the civil rules, applies only when the language of the rule is substantially the same. Article 1, emphasis added. In making this argument, Laura completely ignores the material differences in the language and argues the rules are all functionally equal. In fact, the federal civil rules procedural requirements are much more stringent than the state civil rule, and the family law rule is even more permissive. Turning to the question of whether the court may sanction a party on its own motion under Rule 26, Laura relies on the 1993 Advisory Committee notes, and you will recall, Jeff and I, we talked about this a lot, that it relied on the notes instead of the actual rule. And Jeff was like, we're going to have to figure out if the notes made it into the rule, because if the notes didn't make it into the rule, then who cares?
Yeah,
you know
the what now?
And by the way, chat, I see you guys screaming every time I say safe harbor, and I'm appreciating it, and I love you. And
I thought that when I first saw it.
Yeah, safe harbor. The secret word.
Mm-hmm.
And you know what's really funny? I know I've played this before, but I'm going to play it again just because it was so funny. Right after that, Baby Jingy decided to make a video, and he was complaining about us reading that, and Jeff was so embarrassed. He was like, oh no, we were screaming the whole time. Wait, let me see which one it was. It was so funny.
What was that poor son of a bitch thinking when he watches the video, and here he just sees me, a colleague lawyer, like, every time he says safe harbor. Oh no.
Oh no. I still need to add him screaming to the going to the board. It's so funny.
Man, he was so nice even to those people, I swear.
I know. He was always trying to help them be better, you know. Turning to the question of whether the court may sanction a party on its own motion under Rule 20. Oh, I said this. She relies on the advisory committee notes. She admits that the court can sanction a party on its own, but she asserts that requires a show cause order. We had talked about this too. Requires a show cause order issued before voluntary dismissal or agreement to settle. This is where the differences in language
between the federal and state rules are most crucial. Federal Rule 11 expressly requires a show cause order and does not permit a sua sponte. Am I pronouncing that right?
Yep, you are. Your Latin is fantastic.
Woo, baby.
Sua sponte,
award with
baby.
that one. C. FRCP 11, blah, blah, blah. A court must issue show cause order and cannot impose monetary sanction unless it issued so cause order before voluntary dismissal or settlement. Arizona's Rule 11 does away with this requirement, instead stating that the court must simply take into account the opportunities provided to the offender to withdraw or correct the violation. There is no show cause requirement at all. A family law Rule 26 dilutes the requirements even further, eliminating both the show cause requirement and the sentence requiring the court to account for the party's opportunity to withdraw or correct the violation. So we have compare rather. The trial court has inherent power to sanction bad faith conduct during litigation, independent of Rule 11. That's interesting, actually. They have the inherent power to sanction bad faith conduct.
That's what the law says. We read it. That's exactly what it says.
To suggest that sua sponte sanctions under Rule 26 require a show cause order, like Federal Rule 11, ignores the differences in rule text entirely. More importantly, Laura received ample notice that the court was considering sanctioning her and a full evidentiary hearing to explain her position. If anything, Laura received more process than even the federal court requires for, again, the sanction. That's an interesting. So she actually received more than required.
Yeah, she received more than required. Also, what's interesting here too is that so you know how he's always talking about how Jingy's always talking about federal court. Oh, he's so big in federal court. I'm so good with federal court. Well, he's relying on these federal rules that don't apply. That's what this is saying. You're relying solely on the federal rules, which doesn't apply in Arizona family court. Dude, we do things different here. It's not federal. As to whether the court can sanction under other authority after finding non-compliance with Rule 11, the case law is similarly unavailing. In Holgate v. Baldwin, for example, the court said it could not sanction using its inherent or statutory power because that would require a finding of bad faith that was not made below, not because it lacked authority. Emphasis added, the district court expressly found the offending party did not act in bad faith, so the infirmity was not with its ability to sanction under other law, but that the required elements were not met in the case before it. Therefore, the district court did not err when it found that Levinson failed to show that Community Bank acted in bad faith to multiply this litigation. To suggest that the court lacked authority to sanction under the law when it simply found no factual basis to do so is patently misleading. And this is exactly what Jeff and I said. We said when we read his quoting of this, we're sure that he misquoted it. Like we'd have to go read the whole thing and find out how, but I'd rather just wait for the appeal reply because they'll explain it. And here it is. He's misleading the court by telling the court that this somehow applies. It doesn't, because there was no finding of bad faith in this case. So if there's no finding of bad faith, then you can't award sanctions. But in this case, Laura Owens, there was a finding of bad faith, and so sanctions apply.
Mm-hmm.
It's not that hard.
No,
you don't have to even be a lawyer.
It makes a lot of sense there
to understand it. The Barber case. It's the same how I discipline my children, by the way. If something happens and something happens that's bad, but there was no fault with the children, they didn't do it, right? They didn't do it intentionally, let's say. It was an accident. They don't get a punishment.
Sure.
But if you find that they vandalized something, let's say, on purpose, then they do. It's that simple. That simple.
They also want to minimize her argument. They want to make it sound like she went in and, she was wrong about a pregnancy. The problem is they want to just flagrantly ignore the falsified evidence, the lies about Planned Parenthood, the things that the judge, called out again as cause, because we're supposed to ignore all of that.
Oh, whoops. How did I do that? That's bad. I just lost my, I hit the wrong button.
Oh no, not buttons.
Did it close? Like what happened? Yeah. I hit a weird button. Okay.
It happens. Sometimes I'll lean on my keyboard or tap.
What the hell did I do? I don't even know how to get out of it like that. Oh, there we go. I don't like that view. I like this one better. Oh, but it keeps unsharing it when it switches. Hold on. That's weird. I've never seen that happen before.
Oh, was it a view issue? Is that what
Yeah, it was a view. It was a view issue. Okay. Where did I leave off? I think I skipped. Yeah, wait. Here we go. It was up. Boy, it moved my mouse too. Here it is. Recklessly, Barber v. Miller. Where I was here. The Barber case has the same outcome. The trial court expressly declined to make a bad faith finding necessary to sanction under other authority because of insufficient evidence, not because it lacked power to sanction. Accord with district court ruling that party acted ignorantly or negligently, but not recklessly or in bad faith. So for instance, like I said, the kid knocked the vase off the table on accident because he tripped versus kid pushed it off the table in a fit of rage. You know, that's different. Barber also discusses the show cause requirement and whether a sanction can be made payable to a party if imposed sua sponte, but it does so in the context of FRCP 11's express provisions
controlling these questions. To amend to require show cause order and limiting penalty to payment to court. In the instant case, the trial court did make the finding necessary to award attorney fees under statute. So the assertion that the case categorically prohibit the court from sanctioning under their authorities after Rule 26 was invoked is just not an accurate reading. You're an idiot. You read it wrong. I love
That's
it.
what we were saying. That's what Jeff and I thought. We're like, we're sure he read it wrong. We're sure that what he says it doesn't say. And
it's amazing.
Sure
It's amazing
enough.
to base your arguments on things like that. I'm reading it wrong. Laura's argument from Radcliffe arises from the same incorrect premise that the federal, state, civil, family rules are substantially identical. Radcliffe says the service requirement in FRCP 11 is mandatory to trigger the safe harbor period. But Rule 26 requires neither service nor a copy of the motion. Compare. So FRCP 11, I'm just going to say 11.
Just say
copy,
11, yeah.
Yeah. Copy of motion for sanctions must be served under. Here's 5, at least 21 days before filing the motion. With 11, different 11, written notice of offending conduct must be served 10 days before filing motion for sanction, and 26, movement must provide written notice of offending conduct 10 days before filing motion for sanctions. All emphasis added.
To support her assertions that Article 26 and 11 have identical requirements, Laura even goes so far as to replace the terminology used in that opinion, where the different requirements of the rules are not helpful to her.
Huh.
Oh, no.
Oh, that's not good.
Oh, no. Compare Radcliffe at 789. Replacing strict requirement that a motion be served with strict requirement that a written notice be served.
Oh, wow. Oh, that's...
Oh, my God.
That's bad.
He misquoted the law. He misquoted the case. Holy cow.
That looks very not just misread, but misquoted.
That's intentional.
Yes.
Is anybody surprised that this dick does this?
No.
They deserve each other, Jingy and Laura Owens. They are the same person. She's out there fabricating sonograms and he's out there fabricating rulings. Radcliffe, he's out there fabricating case law. This is unbelievable.
This will get awkward.
Wow.
That is insane. I mean, that's a big difference. A motion versus a written notice. Yeah, exactly.
Sorry, I interrupted you with my silly music. You were saying that's a big difference. Yes,
it is. I mean, you're changing motion to written notice.
This is unbelievable. These things are not the same. Motion, written notice is not that he could have replaced it with filing.
Yeah.
But written
notice
notice and motion are two totally different things. This is unbelievable. Yeah, now he needs to get hit with sanctions by the appeals court. Yep, that's absolutely correct, chat. Holy God, did anybody... Omar, did you catch this? I don't know if you even went over this. I don't know if you guys went over this yet. I haven't been paying attention. We've been stuck in a Hales tornado for a while, so... Wow.
Somebody said that deserves a snake chorus.
Oh, it does. He is the devil. Wow. This is unbelievable.
Fraudulent mofo, man.
I am floored by that. This might be one of the worst things I've ever seen. I've seen lawyers do some snaky stuff, like, misinterpreting on purpose stuff, but this is a full-on replacement of a word. Like, what, two things that don't mean the same.
Yes, with
one
a
of
beneficial.
These things is not like the others. One of these things just isn't the same.
Yes, and when you replace it, it replaces it with a beneficial statement.
This is so bad. Oh, I can't wait to show Ian this. I gotta show Ian this. Hold on. I gotta take a screenshot and send this to Runkle
I already took a
right
screenshot
now.
just to laugh at for myself.
I'm sending this to Runkle right now. Unfreaking believable. You know that Runkle is covering him in another case. Did you know that?
Yeah, I did.
In the what is it? The plastic. What do you call those? 3D printing gun thing. Yeah. Let me send this to Ian. He's gonna laugh. This is terrible. I'm gonna have Ian on here one day so we can talk about this. Good Lord, is this awful?
This is random, but I like this too. Check out this name for the other guys. Beelzebubbles.
Beelzebubbles.
Beelzebubbles. That's good. I like it. Yes.
Echard appeal reply.
Beelzebubbles.
He's gonna flip over this. This is so unethical. This is so wrong. I would love to see my sister's response to this too. God, I need to get her on here. Yeah, the chat just said, I want to know what your sister thinks. Should we call her and see if she answers the phone and I'll read it to her?
Sure.
Let's see if she answers the phone. She's probably working. She's always working. She's probably in court, but we'll try. If she's in court, she won't answer. I gotta read this to her. Hey, you know who's not here? Alex. Where's Alex? My cousin's not here. She's gonna be so pissed. She's been asking me if I can cut. When am I gonna go back to Laura Owens? I didn't text. She must not have gotten the notice. She's gonna be so mad. Hi, you're on the air. You're live. Don't say anything stupid. All right, not that you would.
Hi, everybody.
All right, we had the chat has to know what you think of this. We just got the appeal reply from Woodnick's team.
Mm-hmm.
And I have to read you this part. To support her assertion that Article 26 and Rule 11 have identical requirements, Laura even goes so far as to replace the terminology used in that opinion, where the different requirements of the rules are not helpful to her. In Radcliffe, they replaced strict requirement that a motion be served with strict requirement that a what do you call those things? He replaced written notice with instead of motion be served. Strict requirement that a written notice be served versus strict requirement that a motion be served.
Well, I mean, a motion is written notice.
Are you serious?
Yes, a motion is written notice.
Why would you replace that?
Well, I don't know, but I don't know that it matters. The point is, if it's in writing, if it's a motion, it's in writing and it has to be served. That means you have been served in writing. You can't come back later and say, hey, wait a minute, my due process rights have been violated because I had no notice of this. If there's proof that it was written and you were served with it, you can't come back and say, well, I didn't really get it.
Yeah, but why would you replace the word motion? He took out the word motion from the original order from Radcliffe.
How does it benefit him? I don't know. Why?
Then replaced it with written notice because he's trying to tell the appellate court that she didn't get written notice, warning, safe harbor warning, even though there was no Rule 26. There was no Rule 26 motion pending, so there was no safe harbor in the first place. But he's trying to convince the appellate court she didn't get written notice of sanctions. So he replaces the word motion with written notice. It doesn't make any sense to me.
Did she get notice in writing because a motion was filed and served?
She did get multiple notices. Yeah.
So it doesn't even benefit him at all to make that argument. That makes no sense.
Of course, it makes no sense. But it also makes no sense to take out the word motion and replace it with written notice.
Well, I think it might just be sloppy because I can't think of how that helps him at all. Because a motion is
hoping they
written
won't
notice.
read it.
But I mean, a motion is written notice. It, by definition, unless you make it an open court, a motion is written notice, right? Motions have to be filed.
Yeah, but he's suggesting written notice as in for the safe harbor. So getting a warning. He's not talking about. He's trying to say something separate from a motion.
He's trying to say. So you're saying he's trying to say she deserves some additional written notice other than an emotion.
Yes.
Is that what you're saying?
Yes.
All right. Okay. Well, I haven't read these rules, so I don't know what a Rule 26 in Arizona is. I don't.
Well,
know
it doesn't really matter because they took it away. He dropped the Rule 26. He withdrew it. So she got sanctioned under sua sponte by the court. And he's trying to say that shouldn't have happened because the Rule 26 motion required notice and she didn't get the notice. And even if Gregg took the notice or took the Rule 26 away, somehow that should have given her safe harbor and he screwed up, so she should get away with it.
No.
I know the answer is no.
I don't think so.
It's okay. MG says, tell her it's basically a Rule 11 issue.
Okay.
The chat says, please take the day off tomorrow and chat with us.
I can't, guys. I've just been in Arizona goofing off for 2 weeks, and I've come home, and my boss has settled a whole bunch of my cases. That stinker when I wasn't looking.
He didn't tell you?
No, he told me.
Oh.
But, I mean, he made the deal without my involvement.
Oh, uh-oh. Well, were they good deals?
I think so, yes. I would like to talk to you about one of them, but I can't do it on the air.
Okay.
But yeah, I think they were good deals.
All right, we'll talk afterwards. I'll call you later.
So I'm just completely flummoxed over here because I've been gone for 2 weeks and now I got to get my life back in order here. And stuff is, just crazy.
Tiffany says, what's one more day?
Who said that?
One in the chat. Tiffany.
Yeah, Tiffany, normally that is not my usual first response. That is typical of me. But I'm feeling the pressure to get my life in order here.
All right. Well, go get your life in order. Thank you for answering the phone. Love you.
Sorry if I wasn't much help. Love you too. Have fun, chat.
Bye. She's funny. So I do get what she's saying, that a motion is written notice, but that isn't his intention here. His intention is to make it sound like this was a safe harbor thing. Plus, even if the court had sanctioned Laura under Rule 26, and even if Laura was entitled to written notice of the offending conduct 10 days before the motion, she received both on December 12th, 2023, more than 10 days before her motion to dismiss, and in Clayton's initial response, non-exhaustive list of alleged Rule 26 violations in Clayton's motion to amend. That's right. That's what we were saying. There was another motion that stated they were going to file. The state rules also make no distinction, despite Laura's arguments otherwise, between the remedies available for sanctions imposed by motion versus those imposed by the court on its own initiative. Interesting. See Rule 11 and 26. Next, to the extent Laura argues more good faith consultation was required, she once again ignores the case history and the language of the rule itself. See Rule 9C2AB. Parties not required to personally meet or contact each other if there is a current order prohibiting contact and the alleged victim is self-represented. Laura had an order of protection against Clayton. She was self-represented in this case at the time of the notice. And the motion for sanctions, Tug, still...
One, two. I was looking at something real quick. It got me curious about something there.
And the motion for sanctions still attached. There you go.
Okay.
Here.
A certificate explaining the efforts to resolve the offending conduct up to that point. Moreover, good faith consultation is a procedural requirement, not a jurisdictional one, and therefore may not be the basis for reversal after final judgment. See, again, we're discussing limitations on procedural challenges after trial has occurred. Laura's remaining argument is that the purpose of the rules is the same, so their interpretation must be the same. If the Arizona Supreme Court intended to make the federal, state, civil, and family rules perfectly identical, it certainly knew how to do that. That's true. That is actually very true, too. This court must begin from the presumption that the drafters of the rules meant to change their terminology, and the words used in the rules mean what they say. Again, see where...
City of Surprise. How'd you like to live in a city called Surprise? Where are you from? Surprise.
So even so, Laura did have opportunities to withdraw her petition before and after Clayton's response. She could have withdrawn the petition any time before response under Rule 46. It depends on the surprise, I suppose. Surprise, you're in an earthquake zone. Yeah, probably not. You know?
Right.
Yeah. And even after the court denied her first motion to dismiss, Laura declined to show an affidavit that she was never pregnant by Clayton in exchange for dismissal with prejudice.
That's right. She had the chance to sign that affidavit. She refused to do it.
Yep.
In summary, the trial court did not sanction Laura under Rule 26, so there is no issue here for the court to properly consider. Even so, Laura misstates the federal interpretation of Rule 11 and ignores substantial differences in the Arizona rules. She also fails to account for the opportunities she had to avoid the outcome she now challenges. There is simply no error here. Issue 2. Laura has not, oh God, we're only on to issue 2. Laura has not shown prejudicial error by judicial misconduct. Standard of review. The controlling standard for alleged mistakes in family law proceedings is harmless error. No cause shall be reserved for technical error in pleadings or proceedings when, upon the whole case, it shall appear that substantial justice has been done. At every stage of the proceeding, the court must disregard all errors and defects that do not affect any party's substantial rights. Exactly what Jeff and I said. Generally, the appellate court affirms absent a clear abuse or legal error and resulting prejudice. Emphasis added and citation omitted. Counsel cannot find any example of Arizona courts applying structural error analysis in a family law case. The structural error doctrine is a creature of constitutional criminal law jurisprudence. A few cases support the use of a fundamental error standard in civil cases, which differs from structural error in that the complainant must still demonstrate prejudice. See, again, he's hung up in federal court in constitutional law, which is not civil court.
So insofar as it applies to civil cases, fundamental error shall be used sparingly. Also, in Title VIII severance proceedings, fundamental error applies only if objection not made at trial court and requires proof of prejudice. Laura cites unpublished cases from Kansas, so we have those, but they too espouse harmless error review that is nearly identical to Arizona's approach.
Hold on, my mouse is in the wrong place. There we go.
In summary, if a judgment can be sustained by substantial evidence apart from the challenged finding, it must be affirmed. In Black v. Black, affirming judgment despite trial court basing its finding in part on the undisclosed interview of children in sole custody. Also another here, unlike in Black, record insufficient to consider error harmless after ex parte judicial interview of child independency action. B. Laura has no proven judicial misconduct. That's a big one too. Whoopsie. Laura uses structural error analysis for one obvious reason. It is the only standard that could result in reversal without demonstrating prejudicial effect.
Oh, we missed a
footnote.
Where was it? Oh, it was up here. Oh, that's because it was after this long citation. So here's what that case law said. There you go.
Following a Kansas criminal law proceeding, State v. Walker, the court will only reverse if the complainant shows judicial misconduct prejudiced their substantial findings. Mere possibility of prejudice is not sufficient to overturn a verdict or judgment.
Because she cannot show prejudice, Laura asked this court to announce an extraordinary deviation from the harmless error standard in civil cases. The opening brief alleges the trial judge performed a secret independent investigation into the facts, which included reviewing and adopting as fact statements posted on social media. Laura draws this conclusion from the erroneous finding that Dr. Deans testified that Planned Parenthood is not open on Sundays. There is no dispute that Dr. Deans did not make this statement during her testimony, although she discussed other aspects of Planned Parenthood procedures learned during her time as a medical director with the organization, that patients must be identified and cannot be seen anonymously. To be clear, Laura's statements and use of fabricated evidence made issue of the location and date of her purported Planned Parenthood visit long before trial. At her deposition on March 1st, she said the visit was July 7 in Mission Viejo, but she later changed the date to July 2 and the location to Costa Mesa or somewhere else vaguely in Southern California, per her April affidavit. This prompted a follow-up with Planned Parenthood and was discussed in pretrial disclosure findings, acknowledging Planned Parenthood had no record of a July 7th or July 2nd visit. Laura's affidavit stating that she went to Planned Parenthood
while traveling in Southern California, July 2nd, 2023. It's referencing false statement to court revealed by Laura's deposition testimony. Ultimately, however, it was Laura's unfulfilled burden to disclose the details of the visit, including the date, location, outcome, and associated records, to explain the fact that none of the locations she previously disclosed had any record of a visit. She testified at trial that she went to Los Angeles Planned Parenthood July 2nd, 2023, under a pseudonym. That's correct. This was wild to watch play out, by the way.
Yes, it was.
Dr. Deans credibly testified that Planned Parenthood does not permit patients to use pseudonyms. Yes, that is indeed correct. No one does, my lord. Anyway,
nope.
Just that drives me nuts that they tried to pull that. And again, that her lawyer is so dishonest. He knows this shit is false. He knows it, and he still won't step away from it. The court made several findings impeaching Laura's statement, including the closed on Sunday conclusion that, although apparently true, was not given in testimony. Laura argues, as she did below, that this assertion must have come from an internet search. She alleges that the trial judge went online and performed an undisclosed investigation into the facts, and she then tried to conceal that misconduct by falsely attributing the testimony to Dr. Deans, who said no such thing. Laura provides no support for the contention that the trial judge had illicit intention to conceal misconduct aside from pure speculation. Logically, had the trial judge intended to conceal anything, there would be no reason to include closed on Sunday finding at all. That's true, actually.
Yeah.
If she wanted to hide it, why include it?
Why include it? Yeah.
It was cumulative impeachment with no impact on the outcome of the case.
Mm-hmm. Exactly. When Laura moved for a change of judge, alleging bias under Rule 6.1, the presiding judge reviewed the record and summarized the harmlessness neatly. Regardless of the source of the wrongly attributed statement about the operating hours, Laura repeatedly lied about the date and location of the visit. Even if the court accepted Laura's trial testimony as true, that she went to Planned Parenthood on July 2nd, 2023, and obtained an ultrasound, Laura had already admitted to altering that image and to providing Clayton a 7-year-old sonogram video of twins she obtained online months earlier.
Mm-hmm.
The UAR discusses innumerable problems in Laura's presentation that have nothing to do with the July 2nd visit, including her tampering with evidence and that it was profoundly obvious that counsel for the petitioner was attempting to coach her answers on cross-examination. Therefore, the truth or falsehood of Laura's ever-changing account of the Planned Parenthood visit was cumulative impeachment, not a critical element of the case. It is nowhere evident how this error materially affected the outcome, unless the court presumes the entire proceedings were somehow compromised, a la structural error. On the contrary, the record is so inundated with Laura's false assertions, many of which she conceded at trial, that the Planned Parenthood Los Angeles is closed on Sunday's finding changes nothing at all. This court need not
speculate about the reason or source of the finding to determine it was harmless in view of the overall record. Yes, that's a good argument right there. 100%. C, if the trial court conducted extrinsic investigation, the facts determined were subject to judicial notice, substantially harmless. So assuming argumento that the trial judge looked up the operating hours of Planned Parenthood Los Angeles, Laura has not proven prejudice. Arizona's evidence rules 201B2 permit the court to take notice of any fact that is not subject to reasonable dispute and can be readily determined from sources whose accuracy cannot reasonably be questioned. Interesting. The court may take notice on its own at any stage of the proceedings and give a party the opportunity to be heard. Laura does not.
There's a footnote.
Oh, okay.
9.
Laura raised her objection to the finding in the notice of change of judge for cause and the motion for new trial, both of which were denied. Denied.
That's right. They were.
Denied. Sit down.
Hey, that's another similarity that certain lawyers have these days, right?
Yes. Lots of denials in both of the most recent cases that we have covered, hasn't there been?
They could get matching shirts. One could have like D and the other nod. They could get together for photographs.
That would be funny.
They would be beautiful together. So Laura did not contest that in July 2nd, 2023 was a Sunday. You know, the calendar shows the day was in fact a Sunday. She also does Los Angeles. PPLA.
Wait a minute, we lost you. I don't know what happened, but your microphone went dead.
I don't know.
You're back. You're back.
I'm back now. Okay.
Yeah.
She also does
Wait
not
a minute.
appear.
Laura does not contest that it was a Sunday, as the calendar shows that day was in fact a Sunday.
Yeah.
Huh.
She's not arguing.
That was my theory, that the judge just looked at the calendar and was like, they're not open on Sundays. And then it just got stuck in her head that she heard that.
Well, it's interesting. They're like, she's not even contesting that, in fact, either. She's just saying the judge shouldn't have known that.
Right.
But that's amazing. She also does not appear to contest the truth of the conclusion that Planned Parenthood Los Angeles PPLA closes on Sunday, although she contends the truth of the statement is irrelevant because it was not in evidence. The question then is whether the court or the trial court could ascertain the fact, file judicial notice.
State v. Rogers illustrates the broad scope of judicial notice in Arizona precedent. Rogers concerned the inevitable discovery of evidence in a suppression hearing. The trial court found a piece of evidence would have been discovered in the defendant's car based on the police department's standard inventory search procedures. The problem was that those standard procedures were not in evidence. On review, the Court of Appeals took judicial notice of the Phoenix Police Department's operations order on the department's website to cure the deficiency of the trial record. The court used the procedural manual and affirmed based on the provisions therein. This was a case I didn't find. I found a different case where that was also allowed, where the judge was allowed to take judicial notice of, I think it was operating hours in a different case. This is a different one, though, so this is interesting. The Court of Appeals determined Rogers was not prejudiced because even though the procedures were not in evidence, the trial court correctly interpreted them. That's interesting. Rogers represents a few key points. 1, judicial notice may be taken of standard operating procedures not otherwise in evidence. 2, judicial notice may be taken at any stage of the proceeding, including for the first time on appeal. Even in a criminal case where constitutional protections are at their most robust, an argument for fundamental error stating the trial court relied on facts not in evidence must still establish prejudice. And the appellate court can use judicial notice to cure a deficiency in the trial record if the underlying error did not cause prejudice.
So the facts of the instant case are not so different from Rogers, even if the trial court searched PPLA's website and misattributed the operating hours to Dr. Dean's because of her other testimony about Planned Parenthood's procedure. That information would be just as capable, accurate, and ready determination by resort to sources whose accuracy cannot reasonably be questioned as the police procedural order. Moreover, the PPLA finding is nowhere near as central to the dispute as the order in Rogers, where the police department's policies were outcome determinative of the suppression issue. Next, Laura contends that a business operating hours are categorically ineligible for judicial notice based on ABA Formal Opinion 478, ignoring that the opinion is not presidential. It's a footnote 9. It's hypothetical 1. Distinguish between essential and background facts, the latter being properly subject to judicial notice from publicly available and reliable sources. Also, see discussing boundaries of judicial notice, including approval of web searches for judicial noticeable facts for reputable sources. That's interesting. So web sources are okay.
This is the one. This is the one that I looked up and read, the restaurant one.
So the restaurant hours hypothetically set out.
I think it was Roe v. Gibson. I think I did read some of that. I think that might have been the one.
So the restaurant hours hypothetical sets out a scenario in which plaintiff sues for unpaid overtime hours, and the judge independently researches the restaurant's location because he believes it would only be open during limited hours. ABA Formal Opinion 478. Pages 6 and 7, the opinion stipulates that the notice facts are, quote, key to whether the plaintiff could prevail on a claim of unpaid overtime,
and therefore should have been the subject of adversarial inquiry. Resolving an essential element of a claim with ex parte investigation, particularly basing the decision on the restaurant's industrial area location instead of its posted hours, is a far cry from what Laura alleges occurred in this case. Again, the challenged finding in the instant case is not critical to the outcome and does not establish an essential element of any claim. Rather, it's just one piece of impeachment material among countless others. Yeah, that was the one he cited, and we read a little bit of it. Now I remember. So because it was critical to the case, that one the judge wasn't allowed to do because the overtime hours at the restaurant, that was what the whole case was about. And so the judge looking into it on his own was not allowed. But this is not a material piece of this case at all, whether it was open or not. Still, we know that she lied because Planned Parenthood came forward and said she's not a patient of ours. We've never seen her, and we wouldn't take anybody with a fake name.
Well, and you have, again, somebody that has been over Planned Parenthood that it did indeed say you can't have anonymity. You can't go under a pseudonym and actually
right. So it being closed on Sundays was just one more small piece in a long list of fabrications and lies. We don't need that piece of evidence to find that she fabricated. We don't need it at all. So it's not material. Moreover, there is Arizona precedent supporting courts taking judicial notice of information on websites, albeit government websites in these examples. Well, you could argue that Planned Parenthood takes government money. They are a pseudo-government organization because the federal government funds them by a lot. Court may take judicial notice of Secretary of State website. And that was in Arizona Public Integrity Alliance v. Fontes, taking judicial notice of deadlines posted on county recorder website in accordance with Peterson. Harmless error, now letter D, harmless error applies even if the trial court independently investigated and did not notify the parties. Even if the trial court investigated without notice to the parties, the standard of review is still harmless error. Black v. Black is extremely instructive here. In Black, the trial judge conducted an off-the-record interview with the parties' children without notice or agreement of the parties. Wow, I'd be pissed.
Wow. Yes, I would too.
The court found, based on the undisclosed interview, that both children wanted to live with their father and only visit their mother.
I'm good with one more page, then I'm going to have to jump.
Okay.
So just note, I noticed there's a few more. So I was like, well.
Yeah. I'm going to finish. I'll finish it today. But yeah, if you have to go, it's fine.
Yeah, I've got one more page. So
okay.
On appeal, mother argued the trial court erred by conducting the interview and that the judgment cannot be sustained absent the interview finding. Critically, the Supreme Court said, quote, although we find no error or no record of an interview and agree that it should only have been conducted pursuant to a stipulation between the parties, we believe that such error was harmless in this instant. I mean, not talking about I knocked over a lighter. That was
oh my god, are you all right?
Yeah, it was just a lighter. It hit a trash can though. I keep a little trash can here to keep it cleaned up, and it's like da 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 da. Sorry about that. But even with the ignoring how this is attached, that's crazy. Oh, you conducted an interview outside with kids? That's not. I'm going to look that trial. I'd actually like to look that one up and see what went on.
Yeah, that's pretty egregious to me.
Yeah. But again, the Supreme Court said, even though the error there was harmless in this instant, because the court acknowledged that the parties should have been notified of the court action, but because there was substantial evidence supporting the judgment apart from any consideration of the interview, the judgment must be affirmed. The relevance of the precedent is difficult to overstate. In Black, just as Laura alleges occurred below, the trial judge independently investigated material facts without notice to the parties. The parties only learned about the interview via one finding in the final judgment, and there was no record of the interview for the Supreme Court to review in detail. Despite these errors, which Laura would argue are structural and require automatic reversal, the Supreme Court affirmed the judgment using harmless error review. Mm-hmm. So also applying Black v. Black and finding error not harmless if nothing in the record supports the judgment. Laura also cites to State v. Anderson, stating that this alleged error is one so severe as to create defects in the trial mechanism itself and affect the entire conduct.
You can finish the sentence. The
conduct of the trial from beginning to end, damaging the framework within the trial proceeds. How?
That's ridiculous.
That is an absurd freaking statement there.
But that's what he's claiming. That's what his argument is.
I mean, this is an interesting thing. I hope people everybody stick around and for sure catch that. I'm going to go situate the kiddo, make sure they're good to go and everything. And
all right. Well, I'll see you tonight at 8.
Yes. Tonight we will go over that. Man, there are some major things, by the way, that ended up coming out today. I think those, oh man, we're going to have fun going over that.
Yeah, it's going to be wild. So make sure you tune in on Tug's channel tonight, That Umbrella Guy. If you're not subscribed, you need to get over there and do that. We'll be there at 8 p.m. going over Shara's newest information dump that she did today.
Man, including an admission of some pretty awful stuff. But anyway,
Yeah,
we'll do
Bruce,
that.
Bruce. He just never knows when to stop.
Thanks for having me on. I appreciate you.
See you later.
Yep.
All right, guys. Here's what we're gonna do. I'm gonna hit some super chats, and then we will get back to we'll get to the rest of it. I don't want to get too behind. Ellie fan, thanks for the 2. Says it's hip to be square. Don't get me started on square bullet points. You know how I feel about it. Wendy Bender, Wender Bender, gifted 5 Megan Fox memberships. Welcome to the Fox Den. All of you who got those. It's weird here, but you'll get used to it eventually. Ellie fan, thanks for the 2. Beanie Weenie money. That's funny. Slug Entertainment, thanks to the 5. Like how I messed up mac and cheese in the microwave? You can show the video. I somehow caught oatmeal on fire. Here's my food money. You need to keep your food money. You need to take cooking lessons. I need to help you. You have problems. He sent me a video of what he did with this macaroni and cheese in the microwave. He's the only guy on earth I know who can ruin macaroni and cheese in the microwave. You know, it's meant for the microwave. Somehow it just was a glop of horror dripping through the plastic or the cardboard container. Also, stop poisoning yourself with Kraft macaroni and cheese. Mama Lori gifted 1 Megan Fox membership. Thank you for that. Welcome to the Fox Den. We love to have you here. Fake Laura Owens, thanks for the 5. Hard hitting, just how I like it when watching my Netflix and Tony Robbins. Oh boy. AFK Garage, thanks to the 5. I'm down 113 pounds in 2 weeks due to cutting out alcohol and sugars in my diet. Since you and Tug have been entertaining for years, here's my SB money, my Starbucks money. Awesome. Thank you so much. And congratulations on the weight loss. Fake Laura Owens, thanks to the 5. Sorry I've been gone. These fake triplets are a handful. I'm in my 10th trimester. Good one. Toadette, thanks for the 11. Love you both. And if you know, you know now. Fake Laura Owens, thanks to the 5. You can use horse urine for a lot of things. Trust me. Oh, God. Fake Laura Owens, thanks to the 5. Let's not use the word facial anytime we're talking about horse urine. That's a Wednesday night I don't want to remember. Slug Entertainment, thanks for the 2. Note to self, if I get pregnant, don't. Fake Laura Owens, thanks to the 5. Okay, haters. Don't believe I have the tism. I changed my name to Corky, and now I have the syndrome. Oh, no. Jack's mom, thanks to the 5. I want to see Elo, Jingy, and the whole ecosystem on a Big Brother type show so they can con and tear each other up. Who will be the worst bad guy? Who wins? I would pay to watch that. Somebody get one of those cutthroat producers on the phone. We got a show for them. Fake Laura Owens, thanks to the 2. Parents' approval? What's that? Fake Laura Owens, thanks to the 10. Fetal sacs are the only sacs I have experience with, and even that is fake. Lisa B, thanks to the 10. So glad you are covering this. Well, it's been a long time coming, I should say.
Phrasing.
And because I needed to get back to this. It's been wild on the Hales case. It's been nonstop on that. And I'm only one person. I don't have a production crew or a team. So working on 2 cases at once gets really difficult. Really, really difficult. But I did want to read this for sure. Lisa B, thanks for the 10. I already said that. But thanks again. Lone Star Living, thanks for the 2. Safe Harbor. Crying emoji. I know. Lone Star Living, thanks for the 2. Be sure to tell Jeff goodbye from all of us. I will. Wender Bender, thanks for the 2. It's just a flesh wound. Just a flesh wound. Rogue Mama, thanks for the 2. It should say mother for Laura. That's true, but they're not calling her that because she never was. And I think that they stopped. They are not doing it because it's false. Fake Laura Owens, thanks to the 5. Safe Harbor? Isn't butt stuff safe harbor? You can't get pregnant. Oh my God. You should take this show on the road. Ellie fan, thanks for the 10. I learned from that other Meg, the cartoon one, that you can have ear schmecks. Thank you, Family Guy, for another bonus hole. Oh, good Lord. I bet Ella would get pregnant with twins still, though. PSA, no things in ears. You know, you laugh, but I have an aunt who went to a chiropractor who swears that he stuck it in her ear while she was face down on the table. She swears that happened. But she didn't look up because she didn't want to be, face to face with it. She just pretended that it didn't happen. Tiffany, thanks for the 2. I need to know what your sister thinks. Well, we found out. Aussie Wombat, thanks for the Australian 30 super sticker. Appreciate you. All right, let's pull this back up. And get back to it. Where the heck did it go, though? There we go. And I need to embiggen. That's what she said.
That's what she said.
All right. The conduct. All right. So she said it damaged the framework within which the trial proceeds. But she also explains that the error could only have been made after trial because the issue of whether PPLA was open on July 2nd did not arise until Laura's thrice changed testimony that day. If Laura is correct that the trial judge read her attorney's blog and made the finding based on what she saw there, then there was no defect at trial at all. That is, unless the court believes Laura's vacuous claim that the judge manifested clear prejudice and or bias early in the proceedings in the form of multiple unexplained adverse rulings against her. Quoting Laura's notice of change of judge for cause at this citation, and again, the impact of the finding is meaningless within the broader context of the judgment. If there ever was a time for Arizona's highest court to deviate from the harmless error standard in a family court case, it would have had every reason to do so in Black, to protect fundamental liberty, the fundamental liberty interest at stake. Santosky v. Kramer. Parents have fundamental liberty interests in the case, custody, and management of their child. That's right, it's the 14th Amendment. Yet the Supreme Court declined, and so should this court. Invited error is not reversible on appeal. Perhaps lost in all this discussion is the underlying reason for the error, Laura alleges. Even a fundamental and prejudicial error does not win reversal if the complaining party was the source of the error. Oh, this is interesting. See State v. Escalante. Party urging the error cannot obtain appellate relief when they are the source. Oh my God. So the fact that she lied, that's the wrong button. Where's my button?
She lied?
The fact that she lied about the appointment at Planned Parenthood makes her responsible for not being able to obtain any appellate relief because she was the source of the error. So she can't lie about when she went to Planned Parenthood and then complain that the judge found out it was closed or whatever because the error came from her in the first place. That's interesting. There is no dispute whatsoever that Laura's misrepresentations are the reason this issue arose. Yep. The opening brief acknowledges, and the record proves, that Laura gave several different versions of her account of the Planned Parenthood visit before trial. She also admitted to altering the ultrasound image she initially claimed to have obtained at the July 7 visit, or July 2? I like this in parentheses. July 7th, July 2, at the Mission Viejo Costa Mesa, Los Angeles location. We don't know. She claimed to have been using a pseudonym, but refused to disclose it. She never disclosed information accurate enough to obtain any original records, resulting in substantial discovery efforts that were entirely wasted. Had Laura been honest, complied with her disclosure obligations, and not changed her testimony yet again at trial, there would be no reason for any of this inquiry. Moreover, Laura alleges one source for the errant finding, comments left on her attorney's blog about the case. Lastly, this is not a case in which hardship to the appellee can be ignored. In structural error criminal cases, the state is obligated to avoid errors. I hear laughing children. They must be home. I have to hurry up. The state is obligated to avoid errors and will not be prejudiced by reversal. State is obligated. Let me read that again. Lastly, this is not a case in which hardship to appellee can be ignored. In structural error cases, the state is obligated to avoid errors and will not be prejudiced by reversal. It will simply conduct a new trial using its vast resources. Yep. Yeah, we said she wasn't. Jeff and I said she's not entitled to a new trial. I mean, to a reversal. If anything, it would just go to a new trial and the same facts would remain. Actually, there would be worse facts. There would be, if this went to a new trial, hopefully it would get more than 2 hours. And hopefully Gregg and Mike would get to testify. And hopefully Mike's computer would, and all those text messages and the faked cancer would come in. In civil cases, however, reversal in the face of harmless error would force the appellee back into litigation without good cause. In the instant case, Clayton did not ask the trial court to find PPLA as closed on Sundays. He did not ask the court to conduct an independent investigation if that occurred. There is no plausible argument that the outcome would have been different but for the challenged finding. Yep, exactly. Preventing unnecessary retrial is both the essence and purpose of harmless error. The reviewing court should not waste judicial or party resources over an irregularity when substantial justice has been done. Absent a finding that the record could not support the judgment, a finding that is impossible here, this court may simply affirm. Issue number 3, the trial court correctly awarded attorney's fees under ARS 25-324, 415, and 809. For issue 3, Laura argues the court erred by relying on 25-324 and 25-415 as basis for the attorney fees and costs award. And we have a footnote. She also relies on the Rule 26 safe harbor argument raised in issue 1, the response to which will not be repeated here. Clayton's responses in this section concern only the arguments relating to the applicability of 25-324, 415, and 809. These arguments are frivolous. 25-324. First, Laura argues that 324 only applies to proceedings under Title 25, Chapters 3 and 4, whereas paternity proceedings arise exclusively from Chapter 6. She cites no authority supporting this limited interpretation, and counsel can find no example of a paternity opinion declining to consider 324. Paternity proceedings nearly always involve determining legal decision-making and parenting time, which places them within the ambit of Chapter 4, 25-803C. Any party other than the state may request determination of legal decision-making and parenting time as part of a paternity proceeding. Paternity proceedings always require determination of child support, which places them within the ambit of Chapter 3. 809, requiring past and future support pursuant to ARS 25-320. Moreover, courts routinely apply 25-324 in published paternity cases. And then we're citing case law. The instant case is no different. Laura petitioned for findings of paternity and determination of legal decision-making, parenting time, and child support. Laura herself requested attorney fees under ARS 25-324 during the proceedings, including by motion and in her pretrial statement. To raise this argument for the first time now, particularly after Laura tried to avail herself of the same remedy, is both nonsensical and impermissible. State v. Gendron. Our adversarial system properly and necessarily precludes injection of new issues on appeal. Now to 25-415. Next, Laura argues the trial court could use ARS 25-415 as the basis for sanctions because the false claims provision of that statute does not apply in a simple paternity case that did not result in the birth of a child. Clayton disputes the no false claims assertion for the reasons described herein. Yeah, there were plenty of false claims, but is also irrelevant because Laura definitely violated a court order compelling disclosure or discovery. Yep. Remember when the judge had to force her to sign the release? The opening brief asserts that there was literally no basis for the court to hold that Laura violated any order compelling discovery, but the court found Laura repeatedly violated Rule 49 even after being ordered to comply. The opening brief concedes that there was also an order compelling disclosure, but asserts that Laura somehow fully complied with that order by disclosing all required information. Yet everyone acknowledges her noncompliance. For example, Laura changed her story about the Planned Parenthood Mission Viejo visit on or about July 7th numerous times, even if there were no other examples. Example, Laura admitting she deliberately altered evidence. The court may treat evasive or incomplete disclosure as failure to disclose. RFLP 65A3, and that is exactly what occurred here. While she failed to provide records of any Planned Parenthood appointment, Clayton presumably sought records from all Mission Viejo Planned Parenthoods, as that is where, up until today, Laura disclosed she sought care. This undoubtedly caused Clayton to incur substantial legal fees attempting to locate records that may or may not have existed, that may or may not exist in Los Angeles, but now appear to have never existed in Mission Viejo. Additionally, Laura acknowledged she altered HCG test results, an ultrasound, and a sonogram. Laura's assertion that she fully complied with the disclosure order is simply not accurate. The trial court acted fully within the authority given under 25415. Now we move to ARS 25809G and separate motion requirement. Next, she argues the court could not award attorney's fees because no motion was ever filed seeking sanctions under ARS 25415 or any of the other authorities cited in the trial court's June 17th ruling. In fact, the parties cited these authorities in filings throughout the matter. Oh, this will be interesting. Clayton's initial response, acknowledging both sides seek award and treating Laura's motion to dismiss as a request for attorney fees. Laura asked this court to declare fees can never be awarded unless a party files a separate motion requesting them. But the statutes do not even require a formal request from a party, let alone a separate motion. She frames the argument this way because a separate motion would be necessary to support her ubiquitous safe harbor interpretation. But there is no such requirement to be found in the statutes. Lastly, Laura concedes that ARS 25809G applies to this class of proceedings, saying the correct statute, 809G, does permit fees to be awarded where a party has engaged in unreasonable litigation conduct, and such conduct necessarily caused the other party to incur fees and costs. She argues that the court could not give this award, however, because Laura attempted to invoke safe harbor before most of the fees were incurred.
Say Rule 26 one more time, motherfucker.
I will get through this. In doing so, she imputes limitations on the statute that cannot be found in its text. The court may order a party to pay a reasonable amount to the other party for the costs and expenses of maintaining or defending any paternity proceeding. So all on its own, the court can do that. 809G. Nothing in the statute declares those fees must be incurred before a given date or case event, nor does it contain any safe harbor or other provision allowing a party to withdraw from the litigation at their pleasure. Had the legislature intended to include a safe harbor provision like it did in ARS 12349, it would have. City of Surprise versus Arizona Corp. Applying expressio unius to find legislature intentionally included and excluded terms in a statute. In a paternity action, such as this one, the statute must necessarily account for defending a paternity action that is falsely premised from its inception, even if more fees are incurred toward the end of the proceedings than at the beginning. Clayton invoked 25809G in his responsive pleading ROA 9 and has since maintained the case was groundless. Clayton sought an order from the court determining he did not impregnate Laura.
She lied.
If other relevant issues are raised in the petition or response, the court shall proceed to resolve all relevant issues in the case pursuant to the rules of procedure applicable to family law cases. Clayton was absolutely within his right to request that relief, and Laura cannot claim surprise or prejudice that she lost control of the proceedings once a responsive pleading was filed. Quoting more case law, Sundstrom v. Flatt. Finding no error in trial court's refusal to dismiss upon petitioner's motion to withdraw pleading, because 46 gives court broad discretion. See also State v. Hansen. Whether to grant a motion for dismissal is within the sound discretion of the trial court. Once a party invokes the court's subject matter jurisdiction, the court has discretion to rule in accordance with the evidence presented. The petitioning party must be prepared. Yeah, I mean, it's like she's arguing that just because she submits a motion to dismiss, he's arguing that the judge just has to do it. No, she doesn't. Otherwise, why would you even have to file a motion? You could just say, we're dismissing. If it's not up to the trial court judge, why do you even put a motion in then? Because it is up to the trial court judge, and because she does have a right to say no. And she did.
Denied. Sit down.
Once a party, the court has discretion to rule. The petitioning party must be prepared for the possibility that the court will not view the evidence favorably to the petitioner. Approving award of sole legal decision-making to respondent without requiring counter-petition. Put another way, an action for paternity is also an action against paternity. Whether Laura's positions were unreasonable at the beginning, middle, end, or all throughout the case, the court has broad discretion to award fees it deems reasonable. Yep. Issue number 4. The trial court did not abuse its discretion in awarding fees for unreasonableness and other litigation misconduct after denying Laura's motion to dismiss. Standard of review. A discretionary award of attorney's fees will be affirmed if there is any reasonable basis for it. Via whatever. The trial court did not abuse its discretion by awarding Clayton attorney's fees. The main thrust of this argument, oh good Lord,
Phrasing,
is that Laura attempted to dismiss the case before Clayton incurred attorney's fees, and therefore any fees incurred after her attempt to dismiss are per se unreasonable. I was really looking forward to this argument because I hated this argument, because there was no way he didn't incur fees before then anyway. But I mean, I was just looking forward to hearing what they were going to say about it. Kimmy, Thrustmaster? Not another Thrustmaster. I bet Elo wishes there was some thrusting. Oh, God. The chat's going to have a blast with the word thrust. Gregg Woodnick should have known not to use the word thrust. Or maybe it was intentional. It's going to cause a total derailment in the chat. This case was light on thrusting. All right, now I have to take a moment and read the chat. Are you done yet with your thrust jokes? Are you proud of yourselves? Are you done yet, or do we have more? I'm waiting patiently. Looks like you're done. Okay. The chat just came to a complete standstill. Did you get shy when I looked at you? What happened? I thrust that you will dismiss my stupidity. Which direction was the thrust? In or out? Thruster set to max. My thrust fell down.
My child just fell down.
Can't believe we thrust ourselves so far into this case. My thrust did not fall down. I choose to believe the choice of thrusting was cheeky intent. Yeah, me too. Let's thrust master into this conversation. Wait, I was thrusting. This thrusting of the evidence is BS. Hark at thee, she says as she owns a thrust master. Oh my God. In Megan we thrust. Oh no, that sounded terrible.
Phrasing.
No one's doing any thrusting here except Mr. Fox. That's it. Oh, we all woke up at thrust. If you were napping, you are now wide awake. If your thrust lasts longer than 4 hours, call Dr. MedJill. He'll just accuse you of dribbling before you shoot. Then Zaner says, go thrust yourself. We thrust, we will get to the end. Oh God. Did anybody see the Instagram that was made for my chat? I can't play the sound, but let me see if I can pull it up because this is so perfect. One of you did this and I freaking love it. It's the funniest thing ever and it's so accurate. Of all the accurate things that have ever been posted, this one's the most accurate of all. Where is it? Where is it? I know I posted it. I did. Where did it go? No, it was before this. I missed it somehow. Where's the Instagram? Hold on. I have to find this because you guys will laugh. This is the perfect timing for it. While you continue your thrust jokes. Ha! I found it. I just have to make sure I turn off the sound before I share it. What? Oh no, Natalie, you set your account to private? Oh wait, hold on. I'm just not logged in. That's why. Ah, shit, I'm not logged in on Instagram, like, automatically? Why would this happen? Why would you do this to me, Instagram? Why? Just, come on. Doesn't Chrome save my thing? I don't know my login. Shit. Maybe it's on Chrome. Let me see. Let me try Chrome. Chrome probably has my settings saved. Ah! No! All right, hold on. Password. We're going to have to do the password manager. There's nothing for it. Just please continue holding while your host tries to beat the password game. I know it must have my Instagram. Are you serious? My password manager doesn't have it? How is this possible? How did I get logged out? Come on. No way. Ah. It's not here. All right, I'm officially logged out of Instagram. I guess I'll never get back into my account and I can't show you this thing and I'm very, very disappointed. All right, anyway. It was very funny. If I find it, well, it's on my Twitter. Dang it. Natalie made me the greatest little meme and it was so funny. And it was all about how juvenile you all are. It was perfect. Thrusting back into this conversation. Flux says, I don't do the thrusting. That's for the young people. I am in the right profile on Chrome. I don't know what the problem is. My password manager just isn't there. I can't do it through my phone because it's a whole thing because I don't have a Mac anymore. So Apple and PC don't talk to each other. All right, I guess we just have to keep reading. And Brad's not available. He was on the way to the airport or something. So he's not available today, or he would be here. The trial court did not abuse its discretion by awarding Clayton attorney fees. The main thrust of this argument is that Laura attempted to dismiss the case before Clayton incurred attorney's fees, and therefore any fees incurred after her attempt to dismiss are per se unreasonable. The opening brief states in pertinent part, had Clayton's counsel simply picked up the phone in mid-December and asked Laura about her intentions, as Rule 9 required him to do, she would have informed him that she was no longer pregnant, and there was nothing further to litigate. Again, at that point, Clayton's fees were literally zero. This argument is particularly misleading considering the history of this case, both in terms of when fees were incurred and what Laura asserts Clayton should have done. First, Both parties had already incurred attorney fees resulting from the alleged pregnancy dispute before December of 2023. Clayton consulted with counsel in the early stages of the paternity action and paid associated fees. Although Clayton attempted to represent himself for some of the OOP-IAH proceedings, he ultimately retained counsel for the evidentiary hearing on November 2, 2023. We all remember that. D'Andro kicked serious ass. The court considered the OOP-IAH proceedings as part of the final evidentiary hearing in the paternity action on June 10, 2024. Discussing stipulation of parties for court to review the OOP-IAH hearings, Clayton's challenges to the validity of the OOP, and ultimately declining to award fees associated with OOP-IAH proceedings. Clayton incurred more attorney's fees and costs leading up to Laura's first motion to dismiss. It is true that most of the attorney's fees were incurred after December 2023, Laura's conduct being the primary reason. But flatly asserting the fees were literally zero when the case was scheduled for administrative dismissal is literally false. I love how he put literally false. First of all, this literally zero is so snarky and unnecessary. The word literally is not necessary. And it's just to be, it's his attempt at being, hey, hello, fellow kids. I speak like one of you. And to respond using it again in a snark fashion is great. To say the fees were literally zero when the case was scheduled for administrative dismissal is literally false. Clayton incurred fees in the IAH matter for legal consultations and costs before December. MG Law says I should try Thrust 69 for a password. I'm certain that's not it. I don't even know what my login is because I never remember my Instagram username. It's a private account. It's just a family thing. So it's not publicly out there. Laura's assertion that counsel could simply have called and talked to her is similarly anachronistic. Laura hired an attorney, Miss Platter, prior to filing the paternity action. Although she did not formally appear in the case, this attorney was actively communicating with Clayton on Laura's behalf. Another attorney, Mr. Lopez, represented Laura in the OOP-IAH matters through October and November of 2023. Clayton's counsel first appeared in the IAH case and directed communications through Mr. Lopez. Clayton's counsel entered appearance in the paternity action on December 12th, but would not have communicated with Laura while she was ostensibly being represented by one of the prior lawyers. By December 22, Ms. Lindvall had appeared on Laura's behalf. On December 29, Laura hired another attorney, Mr. Keith. After Mr. Keith withdrew on March 12, Laura hired her current attorney, Mr. Gingras, Baby Jingy. Wah, wah, wah. You remember him. Throughout this time, Clayton was not in any position to speak to Laura directly, nor she him. What was that? Hold, please. I just heard something. A big crash. Hold on. All right, crisis averted. Apparently there was no large crash. Perhaps I was hearing things in my headphones. I don't know. Was it you, chat? Did you do something in the chat? I know the mic was live. If I cut the microphone with the music, it cuts the music too. So it was a no fault crash. Apparently there was no crash. Well, they said there was no crash. They could be covering it up right now, whatever it was, but it's okay. The adult child is home. So whatever it is, she'll take care of it. Throughout this time, Clayton was not in any position to speak to Laura directly, nor she to him, because of the OOP IAH orders. The point of this history is that Laura was nearly always represented by counsel in some capacity. There was never a meaningful time Clayton's attorney could just pick up the phone and talk with her about the case. More importantly, even in December, Laura was still discussing the pregnancy, despite now asserting she knew she miscarried on November 14th, 2023. Compare OB 11/14/2024 with this other exhibit from Laura's December 8th, 2023 article on Medium. I won't be sharing updates regarding the status of my pregnancy with Clayton. I kindly ask not to receive congratulations or engage in discussions about Clayton and my pregnancy. If Laura truly believed the trial court had a duty to end the case in December 2023, she could have filed a special action. The proper vehicle to challenge the denial of a motion to dismiss is not an appeal, but a petition for special action. If she was correct, as she argues, this would have avoided the subsequent proceedings. Instead, she deposed Clayton on February 2, 2024, and expanded the litigation through her disclosure and discovery antics, bizarre motion practice, and other conduct. Yeah, she did that. She did that. She didn't have to. Why, if she wanted to dismiss it, why did she depose him? Meanwhile, despite Laura's current claim that she was involuntarily forced to remain in the litigation, Clayton repeatedly offered to dismiss the case and withdraw all claims if Laura admitted she was not pregnant by Clayton and apologized. See all of the exhibits. Even before filing her motion to dismiss on December 28th, Clayton's counsel provided a simple affidavit for Laura could have signed to end the case. The affidavit said, I was never pregnant with Clayton Echard's child or children and assented to dismissal with prejudice. Clayton's goal was not to torment Laura or run up attorney's fees. He needed confirmation, either in the form of a sworn statement or a court order, that he did not impregnate Laura to undo the damage her allegations had done. Exactly. Yup. Obviously, she did not accept these offers, but she did threaten to sue Clayton for $1.4 million in a collateral action unless he agreed to unconditional dismissal in the paternity case that she initiated and cancel her deposition. The balls on this woman are incredible, really. Lastly, the opening brief asserts the amount of the fees is not reasonable because of the technical and procedural arguments being made. But it does not effectively explain any challenge to the amount of fees awarded beyond referencing the objections made below. Therefore, to the extent Laura asked this court to review the substantive application for fees on such grounds as the reasonableness of the hourly rate, the time expended, etc., the opening brief does not articulate those arguments. They must be considered waived. Interesting. Issue number 5. Laura should not be awarded attorney fees on appeal. This argument asserts Laura is entitled to fees on appeal. So absurd. Because of Clayton's other conduct of aggressively litigating this paternity establishment action despite knowing Laura was no longer pregnant. Laura's argument that Clayton should not have continued litigating after the alleged miscarriage is anachronistic at best, because no one other than Laura knew whether she was pregnant or when that pregnancy had ended. By the time of the motion to dismiss in December, only Laura knew about the 2 sacks she passed in September or October, or July 2023, as she later alleged. Only Laura knew about the October 16, 2023 HCG test showing Laura had either miscarried or that miscarriage was inevitable, or it showed she wasn't pregnant at all and just had some kind of, elevated HCG for unrelated issues, unrelated to pregnancy. Dweens. Just saw your chat. That's really funny. Oh, Shizzy in the chat? Hey, Shiz. Laura had either miscarried. Okay, on October 18th, Laura filed a request for pre-decree mediation, arguing Clayton even acts as if the unborn children don't exist, despite a preponderance of the evidence. I love how they've put this in here 3 times. They love this. They know this is going to make the court laugh. The preponderance of the evidence instead of ponderance. And on October 24th and November 2, Laura testified she had a high-risk pregnancy, was 100% 24 weeks pregnant, due on February 14th, and was being actively seen by doctors McCool and Higley, who she saw last Friday. On October 25, 2023, Laura testified in support of the validity of the sonogram sent to Clayton and that she believed she was having fraternal twins, 1 boy and 1 girl. She also frequently stood up and rubbed what appeared to be a swollen abdomen while on video during one of these hearings. At one point, she asked if she could show her belly on camera to prove she was pregnant, including screenshot and timestamps of hearing recording. In short, although Laura knew all of these facts about the alleged miscarriage, she continued to assert she was pregnant in sworn testimony and court filings. Laura did not give any detail until the status conference on February 21, 2024. And that footnote says Laura's motion for confidentiality and preliminary protective order filed January 17th references her miscarriage in the context of information she did not want disclosed, which also included previous relations, previous pregnancies, etc. It is not clear whether her miscarriage was meant to convey she experienced a miscarriage in this case, or if she was referring to a past event. Even in her December 28 motion to dismiss, she asserted she was not now pregnant without any further details. Clayton was appropriately skeptical of the assertion and asked for documentation. For example, if Laura miscarried November 2, a reasonable assumption given her testimony that day, the miscarriage would have resulted in the issuance of death certificates to the Department of Vital Records. By this time, Clayton was also aware of Laura's past litigation alleging a coerced abortion and intentional infliction of emotional distress against another person. Laura later commanded the court to take judicial notice of that action, so its existence became part of the trial record. Obtaining proof of how the pregnancy ended would certainly help to elucidate whether there was a pregnancy in the first place, and Clayton was entitled to that evidence. When Laura moved to dismiss the action, Clayton had already filed his responsive pleading and made affirmative claims for relief. Clayton objected to the dismissal because his claims, including a determination about whether Laura was ever pregnant by him in the first place, still needed to be adjudicated. The court followed proper procedure when finding voluntary dismissal was not appropriate and maintaining the action to resolve the remaining claims for non-paternity, attorney's fees, and sanctions. Boy, I need coffee. My throat is dry.
That's what she said.
I know. Let me see if my daughter will bring me some. Can you bring me coffee? There's no K-cups. Please use coffee in bag. Please, 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 please. Thank you. Okay, she said she's going to bring it to me. Yay. Where was I? The court followed proper procedure when finding a voluntary dismissal was not appropriate and maintaining the action to resolve the remaining claims for non-paternity, attorney's fees, and sanctions. Yeah, right. The petitioner loses under ARL Article 46, the petitioner loses the right to unconditional dismissal after a responsive pleading is filed. Ah, interesting. I did not know that. Voluntary dismissal after a responsive pleading requires a motion and the court's approval. The court may dismiss a petition after a response is filed, but only on such terms and conditions as the court deems proper, including the resolution of any claims by the responding party. Here, the court determined dismissal was not proper because Clayton's claims needed to be resolved. Yeah, exactly. Little to no thrust DNA. No, in Arizona, death certificates are issued after 20 weeks. 20 weeks and up. At that time, so actually, it would have been, I think, October would have been her 20-week, or the end of October, beginning of November. Well, Rachel, we have different laws in the United States. So every state has their own fetal death laws. Each state is different. And Arizona's is 20 weeks. No K-cups? Why are you streaming? That would be an emergency situation in my home. Well, there are some K-cups, but it's the stuff I don't like. So I just want regular plain coffee. I don't want flavors. I don't want any of that. I like my coffee like my haters, extra mad and bitter. Just like Tug says. At that time, Laura's primary argument for dismissal was that the court lost jurisdiction once the pregnancy ended. It did not. Subject matter jurisdiction, grounds, is established at the time of filing and cannot be ousted by subsequent actions or events. Fry v. Garcia. And also at the State v. Howell and Trust Corp v. Faust. Jurisdiction depends upon the state of affairs existing at the time it is invoked, and once having attached is not lost by subsequent events. Internal citation omitted. Arizona law favors retention of jurisdiction unless divestiture can be clearly and unambiguously found. The only divestiture language Clayton's counsel can find in the statutory scheme for paternity actions is in ARS 25805. Effective death, absence, or insanity of plaintiff. That statute permits the state to assume the petitioner's place in those circumstances, but is silent as to the effect of death of the unborn fetus or child. Interesting. Had the legislature intended to abate paternity proceedings automatically in the event of a miscarriage, it certainly could have done so. It is not difficult to imagine scenarios in which continuing the paternity action after miscarriage is necessary and appropriate, such as for insurance claims, yep, or establishing the family's standing to sue for wrongful death, yep. Conversely, in cases like this one, the putative father may have need to prove non-paternity even if the pregnancy does not end in live birth. To the extent Laura argues the trial court's jurisdiction automatically abated upon her allegation she was no longer pregnant, this argument must also fail. Yeah, Clayton had a right to repair his reputation through the court because she tried to destroy his reputation through the court. And he had a right to have it fixed. Echard requests an award of attorney's fees incurred on appeal pursuant to 25-324 and 809G. Owens has maintained unreasonable petitions throughout the proceedings. Her appeal, particularly regarding Rule 26 and the fees statute, is this my coffee?
Yes.
Yay. Thank you.
You're welcome.
I love you.
I love you.
Oh, it smells really good too, but I do have to transfer it into my steel mug so it will stay hot. Yes. This is only my second cup of the day. I am really behind on my coffee drinking. I usually have like 4 or 5 by now. You guys owe me for sitting here all this while with no coffee. How are the super chats going? I'm just kidding. They're going great. No worries. All right, let's see. But don't forget to hit like and subscribe. Make sure you hit like and if you're not subscribed, do it now. And if you are subscribed, make sure you double check because YouTube is asshole and likes to unsubscribe. Any tips that come into Cash App or Venmo today will be used for my Utah trip, which I am going to Utah to say goodbye to our dear friend, Legal Vices. And I am both dreading it and looking forward to it for reasons. Obvious reasons. I'm going to get to meet people for the first time that I've never met face to face. And so that's positive. And we're going to have a little road trip together, which is going to be hilarious. And I'm sure we're going to laugh a lot and probably weep and sob. And also dreading saying goodbye. So, all right. Attorney fees on appeal. We already did this. Instead, her appeal, particularly regarding Rule 26.
Say Rule 26 one more time, motherfucker.
And the fee statutes does not make colorable claims for interpreting or expanding the law. Instead, her appeal mostly seeks to misdirect this court with incomplete, inaccurate, and sometimes even substituted recitations of the record and precedents. Conclusion. The trial court admirably resolved this difficult matter and wrote a detailed, comprehensive, and legally complete judgment. The appellant has shown no reversible error. Clayton requests this court affirm the trial court's judgment in all respects, deny petitioner's appeal, and award respondent his reasonable attorney fees and costs on appeal, including this appeal. He should get attorney fees for this because they should have given up and said, okay, we're done. She should pay. And then we have the certifications, and Marcus has signed it. And we are done. Wow. Well, I thought it was an excellent reply. I actually have no complaints about it. I think it covered everything perfectly. Frankly, I think it covered everything the way it needed to, and it was not overly cute. You know, the appellate, it wasn't cute at all. The appellate court does not want to hear your cute attorney shit. It really doesn't. It just wants you to get to the facts. And they did that. All right, let's get to your super chats. Ellie Fan, thanks for the 2. This is the Temu Pee-wee Playhouse. I know. I can't even do it anymore. I have no heart for it. Shizzy Wiznut, thanks for the 2. W balls like that. Sure, it was not a self-prego. With balls like that, sure it wasn't a self-prego. Yeah, good Lord. Just the balls the size of church bells. It's just too bad she doesn't use that chutzpah for good, you know? Why does she choose violence? I don't understand. Slug, thanks for the 10. I'm doing a cooking stream next week. I'm gonna need help. Yeah, you will. Let me know. Let me know when. I'll try and help you out. I'm not sure if you can be helped, but I will try. No more instant mac and cheese. K-Matt Red Queen, thanks for the 5. Coffee Pods Replacement Fund. Yeah, I need to get to the grocery store. Thank you. L. Lou, thanks for the 2. Give Jeff a last safe harbor. For us. Equality, thanks for the Canadian 5. Safe travels to Utah. Please make sure Jeff's family know how much we love him. I will. It'll be really good to get to meet Connor, and you know we've been talking a lot, but to get to meet him in person. And I'm just so sad I never got to meet Jeff in person before he died. You know, I'm really sad about that, and I wish I had gone to one of the meetups. You know, I wish I had, but I always had other stuff that I needed to do at home, and I wasn't able to go. So I did it though. We made it through this, and we have not. Who is rating me right now?
It's Hangy.
Do not come in. No. What do you need though, babe? Here, I'll turn off the camera. What's up?
I got back home from school.
I heard you got your homework done in study hall. Nice work. Wash your hands, change your clothes. You know the drill.
My entire body feels like crap.
Why?
Volleyball. is the most. I'm not even kidding when I say this. The whole gym floor was drenched in blood and
blood.
Yeah.
What?
Blood and sweat.
That must have smelled great. An elementary school gym, all sweaty and gross.
I'm not even exaggerating. Like 2 gallons.
Why? Who got hurt? Did you get hurt?
No. Well, yeah.
Who got hurt?
Well,
who was bleeding?
Everyone.
Oh, come on. You're making stuff up now. Listen.
It was. I am still sweating. It's
all right.
ridiculous.
Listen. So listen. Go change your clothes.
I'll stop rating now. Get back to your stream and get rich.
Listen. Wash your hands and change your clothes like always. Can you do that for me, please?
Okay. Bye, chat.
All right. Bye-bye, babe. Thank you. You have no idea how long it has taken for me to get him into a change your clothes and wash your hands as soon as you get back from school because, oh my God, the germs. That's where it all comes. Yeah, it sounds like dodgeball, not volleyball. Yeah, blood. I was like, I would believe the sweat, but blood, I don't think so. One person probably got a cut or something. I don't know. 10-year-olds like to exaggerate. Get back to your stream and get rich, he says. He really doesn't know how any of this works. He thinks he does, though. It's funny. All right. Where was I? Oh, I was just going to close out the show. So I am going to, let me see if anybody is streaming right now that I want to send you over to. Shall we redirect? Who's live? Are you rating me again? Okay, no, he closed the door. Oh, looks like Broken Baker is live. But John Della Rose is live. I have not redirected you guys. He's never live when I am. So here we go. I'm sending over to John Della Rose. Please tell him I said hi. He's doing some kind of entertainment thing right now. Please tell him I sent you and check him out. He's got a good channel and he's a good guy. So go check him out. All right. We have not played Minor Perjury in a long time. And I feel like Minor Perjury applies here. Did I upload it though? No, I think it's in in here. So let me go look for Minor Perjury. Search. There it is. Let's play that. I know it's one of your favorite songs. All right. See you guys later. Have a great day. And remember, tune in to Tug tonight at 8 p.m. Eastern Standard Time. We have a huge show for you tonight. It's going to be great.
To tell the truth, oh yes, I did.
Wait. Stop. I screwed up. Cash apps. Hold on. The Cash apps and Venmos. Hold on. We will do it. I promise. But I cannot miss my Cash App, folks, because I do truly appreciate that. It gives me instant money for my road trip. Well, flying and road trip. It's a whole lot. Why won't it let me see the notifications, though? It's not loading. That's not good. All right. Well, they did come up on my, they came up here on my Apple Watch. So maybe I can look at my notifications. Is that even a thing? K-Dubs sent 20 for the travel fund. I appreciate you, K-Dubs. Who else? It was somebody else. There was somebody else too. I saw it pop up. God, this is difficult. Why is my tech not working? Now I have it. Okay, so it was K-Dubs over there on Cash App. Thank you very much. And on Venmo, let me see if there was anything on Venmo. Nancy, I appreciate you. Nancy says, YouTube, I really wish I could do more, but here's a small amount towards your trip. $50. That's not small. I'm continuing to pray for you as you navigate this new chapter without your dear friend. Thank you. Thanks, Nancy. And Steve. And Shelley. And Renee. Thank you. I thought I was out of tears. Damn it. I love you guys.
My hand and nodded my head. Nothing but the truth, so help me God. I swore on the Bible, and Dingus gave me the nod. Then I spun a tale so wild, no one could believe. Fake scans only Adobe could achieve. Story keeps changing, sonograms rearranging, and judges ain't paying attention to anything. What do you mean it's a felony? It's just a little minor perjury. When your twins disappear, it's not an emergency. It's just a little minor perjury. It's just a little minor perjury. It's just a little minor perjury. Oh, oh, napkin lady is a cog in my wheel. Her notemaid got me a TEDx spiel. Now my lies are repeated everywhere, doing interviews with lead press on hair. How did she hear us through all that noise? Why do you ask? Everybody knows it's the bad boys. They're the ones at fault, it's not me. I just committed a little minor perjury. Why don't you just take me? Instead you made me commit minor perjury. Why are you coming at me? It's only a little minor perjury. And clearly a survivor, and I paid for it on Fiverr. Or couldn't you just take me? Instead you made me commit minor perjury. It's only you coming at me. It's only a little minor perjury. I'm clearly a survivor, and I paid for it on Fiverr. Why couldn't you just date me? Instead you made me commit. Why are you coming at me? It's only a little minor perjury. Oh yeah, I'm not going to jail. There's never gonna be no bail. The system ignores liars like me. It's only a little minor perjury. 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 The system ignores liars like me. It's only a little minor perjury. It's only a little minor perjury. Oh, I'm not going to jail. There's never gonna be no bail. This system ignores liars like me. It's only a little minor perjury. It's only a little minor perjury.